Hello folks and welcome to this presentation. I thought I'd jump on for you folks still in the public in order to update you as to what I've been getting up to over the last year. If you recollect, those of you who've seen my previous presentations surrounding the forensics on the forms, I published this back in March 2024, I believe. You can see here where we discovered when doing and dissecting all the forms surrounding my birth here in Australia that it was declared that this entity, right, was a stillborn who died without a will intestate, imbued with a criminal charge and made security for all the national debt. And we kind of worked out that it's linked to the placenta, the twins in the womb mentioned in the Bible, and that has otherwise established this Holy Ghost kind of straw man entity, ens legis, government created fiction that we then incorrectly step up as surety and agent for, which is obviously then pledged for all the debt to a corporation that is otherwise printing money or creating money from an account at zero balance and charging interest on that and issuing that to the government in order to fund it, where they're captured under a chapter 10, 11, 12 bankruptcy, all right, so which is kind of revealing all the fraud. So I did that initially, and what I want to do today is just quickly skim over that and otherwise, share also some of the things I've been working on. And I'm currently got a case pending, a court case pending in order to liquidate my estate that we'll go through. That I've got some documents to pull up. And otherwise highlight at this stage of my journey, being 5 years in since starting this, kind of coming into the knowledge of the straw man back in the end of 2019, showing you folks, all the things that I've kind of refined and now the technologies I'm kind of using in order to invite those of you who might still be in the public into the private, become a private member, right? Join the Telegram group, which I'm updating, frequently, the things I'm working on. All the other members that are on board as well, over 152 members at the moment. These guys are all active as well, sharing successes and great research and just step by step, walking you through on my website for my course and through Telegram for the documents I share in the private, how to set up your estate, control your estate, protect your sweat equity, claim all these, statuses in regards to tax exempt status, learn the latest bond technologies utilized in the back of your birth certificate. How to claim allodial title for private conveyance when obviously setting up your own court of office under your own hand as seal, using the postal road mechanics. Then, sharing all the rudimentary technologies in regards to dealing with debt discharge letters and cases, how to implement, obviously now the knowledge we have of what banks are in regards to misrepresenting what they do. As we know through Richard A. Werner's wonderful empirical papers, they do not lend money and they do not take customer deposits. They're in the business of purchasing securities and creating credit from an account at zero balance, right? And that's otherwise what I updated later on as I came into that knowledge, especially with the banking law as well from Alan Tyree, for those folks who are familiar and have been, tuning in on my YouTube channel and on my website, that obviously then are integrated with the original presentation that I did and published that 8 months ago, merging, this knowledge of banking and what Richard Werner found into doing the forensics on the forms and the straw man trust and the system we kind of find ourselves in. In order to, again, like I said, give you guys an invitation to treat and show you now where I'm at, which is pretty much at the peak. Safe to say, having the knowledge and, walking the walk, now I can talk the talk, that it has revealed a lot to me. And obviously I've been trying to liquidate the estate privately, but these guys keep ignoring my requests. So I'm actually actively involved in a pending court case in order to seek leave of the court to commence proceedings against the Crown, that I will share with you folks towards the end of this presentation. So I'm still able to, there's no NDA or anything involved. That might give you folks inspiration going forward as to how you might be able to go after this yourself and put pressure on these guys. Because at the end of the day, we're all here together as a collective of humanity, part of the same family. And it's through each and every one of us that comes up into this level of knowledge and has the confidence then based on the knowledge that is backing you with the things you're doing in order to put pressure on these guys to start changing the system from within. It literally does start from within because each and every one of us are the ones we've been waiting for. There's no one outside of yourself that's going to come and save you, unfortunately, how to be the bearer of bad news. But that external savior program they've been relying on for so long, so it's up to each and every one of us in order to help each other raise the bar, get up to that level of awareness where the confidence is just irrefutable and irresistible, and you're steadfast, knowing exactly what to do, and you can stand on your own 2 feet, not copy and pasting, and put, you know, applications together like this and go after the crown and what is rightfully ours in order to amend the records, okay, that I will walk through to show you folks exactly what I've been, you know, doing and what is currently underway, in order to invite you also to come back into the private, where I can obviously reveal more going forwards, where everything's protected in the private. Private is the remedy, as we know. The public is where all the debt is, where all the dishonor is. All right, so you can see exactly what I've been working on, what I've perfected over the years. And yeah, going forward, there's a lot more room to now apply these technologies that I've got set up, especially with like the bonds and stuff like this. I'll quickly show you the Treasury set-off bonds, the back of the birth certificate, A4V examples, you know, and obviously claiming allodial title to private conveyances and everything else that goes with it, tax exempt status. And yeah, we'll go through obviously, you know, revealing how the bonds have been very powerful, which revealed obviously the nature of the system that I covered in previous presentations, but kind of just try and knit it all together and show you what I'm working on in regards to also putting together a will in order to dispose of that estate, okay, that had been declared as stillborn. He died without will and testate and be with a criminal charge, made security for the debt, in order to also share, because you only, you know, you get back what you put out, and because we're all in this together, I'm going to put it out there to the universe, to the Ethernet, to the internet, okay, and collectively help raise the consciousness of the viewers watching this video. Encourage you to share it with others as well on this journey that might help you put these kind of final pieces of the puzzle together. And if you're feeling inclined to want to kind of, you know, jump on and come on board in the private side and join this movement, okay, the Sovereignty Masterclass, and support, pay your way forward, as, you know, everyone has done who joined and became members, as I've done with, you know, many masters before me that I used as stepping stones to get to where I am, in order to invest in yourself and in this movement, so we can all help each other raise up the level of consciousness, become, you know, sui juris, independent, not depending so much on the system, taking control of our estate, our four corners, our paper, document contracts and vessels, and then inevitably get to that point where we can work out the things needed in order to get them to liquidate the estate and collapse everything and get us to be recognized on the private side of the ledger, in the private, where we got, you know, full access to our remedy basically, which I know they're very reluctant to want to give, but I'm knocking on the door and I'm putting the pressure on them. And I know other individuals have done this, and there seems to be one pathway, which is through the courts, where this needs to be done, when obviously issuing a will and everything else that goes with it. Okay, so yeah, sit tight, grab a cup of tea. Obviously, you know, end of last year I kind of had a bit of a hiatus in order to write my book, which these presentations were based off of, because my soul was urging me to, you know, get this done, because I had it all rattling around in my brain and kind of scattered on different documents and notes with things that I kind of, you know, documented over the years that I just needed to put into one place, which then helped me kind of dissect more and decode more of what's going on with the occult, spirituality, science, merging spirituality with science, right, doing the cross-examination work, how it all ties in with what's happening down here in the 3D on Earth, with obviously the strawman deception and the banking, okay, and where it all stems back to, given Pierce Abac's research and my research and everyone else as well, that it is directly influenced and seeded and set and designed by extraterrestrial forces. There's no doubt about that. That's clear as day when you go through, and I've done my research. We are living in a post-disclosure world, okay, so we can see who the true enemy is, and where the remedy actually lies is within us. Again, it all goes back to us, and we're the ones we've been waiting for, and we just got to kind of rise up, dispel the fear. How do we dispel the fear? By getting educated, okay, and that's the secret. Is fear is only bred out of ignorance, and what dispels fear is obviously knowledge, okay, because knowledge is power, and that is what's going to literally set us free, because with knowledge comes truth, and truth is going to set us free, okay, but we're all here together to help one another, and hopefully this presentation is going to do exactly that. All right, so I'm just going to skim through this presentation, which is exactly the same from the previous ones that I've done, but just with a few slight changes in order to remind ourselves, like a revision homework, what's going on, what the setup is, where we are, and, you know, what the remedy is. And then I'll share some of my tactics and technologies going forward as to what I've been getting up to, and obviously the court case, which might give you inspiration to kind of do something similar. And like I said, jump on board and join, invest a little bit in yourself, and with my work, support my platform, and yeah, you can then gain access to all the private documents and get up to speed and set yourself up to be free and a master of this system of commerce. So as you can see here, these are the documents I did the forensics on beginning of 2024 when I relocated back to Brisbane, Australia, the place of my birthing and born event. So if you recollect, in the Bible, in the good book, it says in the beginning was the Word, and the Word was with God, and the Word was God. Okay, so who is God? As we know, it is the words, and that's what these folks obviously rely on in regards to the different definition of their words, because we know that they have many legal dictionaries that have different definitions to the words that we otherwise use and have been taught of what we think the definitions are under plain simple English. Okay, so you've got the local dictionaries, which here in Australia is the LexisNexis. Okay, and then you've got the Black's Law and the Bouvier's Law, which is kind of more international. And then you've got the definitions given in each act, okay, and legislation and bill that is passed in Parliament. And then through dissecting those three, you can see what is exactly going on with anything involved with contracts with the government, the banks, and these guys. So, and the earth was without form and void. Okay, this is obviously looking through the lens of analysing it from a two-dimensional point of view, given the system we're in. Okay, a form contracted us into their world, and maybe a form can get us out. Okay, the Holy Bible is the code book. It is the rule book for the age of Pisces that we have been in for the last 2,000 years. Moses in the Old Testament governed the age of Aries. Jesus probated the age of Aries and brought in the New Testament. The last will and testament, we are now entering the age of Aquarius, which will usher in the so-called 1,000 years of peace in Christ's millennial kingdom. Okay, everything is done by our declaration and by our will. All right, so we've got testament from LexisNexis is historically a will dealing only with personal property, but nowadays includes wills generally. And then a will, taken out of Black's Law, is a wish, desire, choice. Also termed human will is also the legal expression of an individual's wishes about the disposition of his or her property after death, especially a document by which a person directs his or her estate to be distributed upon death. Okay, and that's the secret, and that's otherwise what I'm going to be sharing with you folks. Okay, at least the first page. Okay, in order to get you into the private to see the rest of it, the will of your straw man. Okay, because that entity, if you recollect, has died without a will and testate. And that means it's escated to this state, made bona vacantia, and they've issued letters of administration to gain control of that estate, in which we're kind of stepping up as surety for, an agent for, incorrectly, which means that we're acting in a trustee de suntore capacity, and then the trustee always has to pay. So not only are we intermeddling with their property, we're acting as trustee de suntore, which is dishonourable, and obviously we've been imbued with the criminal charge as well of that entity. So we're in a very precarious situation, which is why we have a tough time whenever we're identified with this entity and stepping up as agent and imbuing it with life, thinking it is us, okay, when in reality that is the being that has been crucified on the cross for all the debt that is unlimited, that these controllers have us in this kind of Ouroboros loop. But yeah, we've got the tickets now and the remedy to break free, luckily. So in the beginning, there were contractions, a ward, a delivery room, the waters that broke with your mother, a birth canal, a birth and a born event, a placenta, a doctor, a crown, and a form. Okay, so the ward, if you look at the definition, is a subdivision of local government area in the LexisNexis, and out of Black's Law is a person, usually a minor, who is under a guardian's charge or protection. Okay, and if you look at particularly the word delivery, under the legal definitions, it is the transfer of actual or constructive possession from one person to another. Okay, and so the whole concept of what's going on with the birth registration is that they're declaring the placenta dead at birth, and through the registration, it is this entity that is then creating the straw man and the name on the birth certificate, that us is the living with the given name is stepping in as surety for, in order to allow us to kind of contract and operate in the world of commerce like a token on the Monopoly board game. Okay, so it's through the placenta that they declare dead, and it set up this entity, and we come along and imbue it with life, thinking it is us when it isn't. Okay, so all of you should be familiar by now in regards to a lot of the analogies and kind of synonyms relating to maritime ambiguity law, the waters, and our berthing and vessels and how they're floating us, on pieces of paper, which are just vessels floating in a sea of space. With the postal roads being the port roads, the port codes, houses being foreign vessels in dry dock, as well as the courts, okay, the lanes are the shipping lanes, the roads are the shipping lanes, etc., etc. Okay, it's all, they've raised the fictional waters over the land through this registration and under this bankruptcy, where the waters have broken with our birth and within the government's banks. Okay, the banks are burst in regards to them being in bankruptcy because they're in debt and they're having to operate under a Chapter 10, 11, 12 bankruptcy under a state of emergency in order to fulfill the desires for the creditors as debtors. Okay, so this entity becomes the debtor and the property of the Crown, which is pledged to service all of the debt. So if you recollect, I did the forensics on the source document this is the equivalent of here in Queensland, which is called the Certificate of Birth. Again, if we see down there, informant means a person who lays in information in respect of a criminal charge and commences a criminal prosecution as a result. And then we have information is an allegation that a person has committed a criminal offence which is laid before a court of justice and is the first step by which a prosecution is commenced. All right. And then we have child under Birth, Deaths and Marriages Registration Act 2003, Schedule 2 in their dictionary. They say birth means the expulsion or extraction of a child from its mother, and child includes a stillborn child. Okay, and then there's a maxim called inclusio unius est exclusio alterius, and this is Latin maxim that translates to inclusion of one is the exclusion of another. Okay, it is a principle of statutory interpretation that suggests that when a statute expressly includes certain things, it implies the exclusion of others not mentioned. In other words, if a statute lists specific items, it is presumed that items not listed are intentionally excluded from the statute scope or application. Then we have under Black's Law Dictionary, a child means an unemancipated person under the age of majority. Okay, so obviously I start to learn that, hang on a minute, it's not all what it seems on the surface. Okay, when you dig a little bit deeper into their definitions, you can see the sleight of hand going on involved with this registration. So by virtue of my father filling out the certificate of birth form and sending it to the registrar entered into his book a stillborn child with a criminal charge who died without will intestate. This registration joined the given name with the name of the father and produced the ens legis government-created fiction, a juristic person commonly referred to as a straw man, evidenced by the issuance of the birth certificate. Okay, we have in Black's Law, artificial person means an entity such as a corporation created by law and given certain legal rights and duties of a human being, a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a human being. Okay, an entity is a person for purposes of the due process and equal protection clauses, but is not a citizen for purposes of the privileges and immunity clauses, okay, and in the 14th Amendment, etc. And then artificial person from LexisNexis is an entity recognized by law, but which is not a real person, for example, a company. Okay, so the way the penny dropped for me when I kind of first got my head around what's happening was seeing the straw man, this entity, as like a corporation soul, okay, which obviously a sole proprietor, which then obviously contracted you into being liable for the codes, acts, statutes and legislation under their so-called trust indenture, right, their corporate charter, in order to abide by, because you're under their ownership, if it were. They were holding legal title. They're the one who issued and created this entity, even though we're the only ones with the indefeasible right and beneficial interest in it, because we're the only ones that are given any value and are the cause of its genesis, okay, with us being born with that placenta entity and the only one that actually gives it life. So we have here persona, again in Roman law. This is taken from, I believe, Black's Law, okay, which is a person, again, an individual human being. And then you can read that in your own time. It just goes into, confirming what this entity actually is. And as we see, you got the definitions carried over from the source document, child and informant. Okay, so once again, you see child where the given name has been joined to the name of the father by this point. Okay, so you've got the given name and then double space. Surname for me is obviously Middleditch. The parents or the pair who rents are down as informant, again confirmed down there, effectively charging the estate and this entity criminally. The birth certificate is printed on security stock paper, proving that we have now become security for the national debt. It can also be interpreted as your death certificate, as it indicates the deceased estate of the placenta, but can also be analogous to a beneficial interest certificate slash trust certificate unit and or a warehouse receipt bill of lading to the Baileys in possession, which of the government, for the public trust, public trustees, treasury, and all other crown instrumentalities administrating your estate. This security is then used by the treasury to back the bonds they issue to the central bank to fund government, as this evidences a new unit of labour that will pay taxes to serve the debt owed to them by the bankrupt debtor corporation that is the government. They will take bets that you've been dumb enough and not been schooled to realise that you're going to step up as surety, an agent for this entity, and take on then the responsibility of servicing all that debt. And they take a commission out of that every step of the way, and that's estate embezzlement. But ignorance of the law is no excuse, so it's up to each and every one of us to correct their presumptions and assumptions of law. So here, securitization, what does it mean? This is out of LexisNexis. It means the substitution of loans by marketable financial instruments. An example is when a bank assets such as loans and mortgages are sold to a company which raises funds by issuing negotiable securities. The beneficial ownership of the assets is shared among a large number of small investors. Securitization began in Australia with bills of exchange and promissory notes, where something otherwise unmarketable, becomes a marketable asset. And then you've got securitise here from Black's Law to convert assets into negotiable securities for resale in the financial market, allowing the issuing financial institution to remove assets from its books and thereby improve its capital ratio and liquidity, and to make new loans with the security proceeds if it so chooses. And for those who need the proof, so obviously the burden of proof is always on the claimant, which is what we're going to get into, which is why doing all the forensics on your forms involved with your birth registration is so important if you want to prove to them that you have the evidence to back your claim, as we'll go through with my Supreme Court case and the affidavit and everything else. As you can see here, security features include 5 distinct watermarks depicting a cascading eucalyptus leaf, etc., etc. I also had that confirmed to me by a guy when I was there at birth, deaths and registration, and I asked him what all these numbers were, and he said, yeah, it's printed on security stock paper, and I had that confirmed via an email as well. So yeah, all very interesting. And he actually confirmed to me the number on the top right is the year of birth for this corporation and the entry number. So by the time on the 26th of February 1989, I was the 5,249th child to be born that this entity was associated with. So the birth certificate is evidence of the Ens League as crown entity created under statute that we then use to incorrectly identify ourselves within the field of commerce when opening bank accounts, getting government IDs, passports, driver's licenses, and social security national insurance within their corporation. This is the death certificate for the placenta that we, the living, have been tricked into acting as surety and agent for our whole lives. This is the entity who the government have declared a criminal and is at war with and is administering the account of because it died without a will intestate and is thus escated to the Crown under the Bonificancia division. By us stepping up as agent and surety and identifying with this name, thinking it is us, we are acting in a trustee de son tort capacity. And as I said before, trustee always has to pay. So for those of you who don't know what a trustee de son tort is, pulled up the definition on Google. It is someone who acts like a trustee of a trust without actually being formally appointed as one. This person takes on the responsibilities and duties of a trustee and consequently is held to the same standards and liabilities as a properly appointed trustee. They are essentially treated as trustees by operation of law due to their actions. And it's because of this status that I've found and have discussed with guys in the group that we can kind of set up a checkmate situation with them when we have the bonds of the treasury when it comes to then accepting for value and setting off bills that they're reluctant to want to perform because we're kind of still in this trustee de son tort capacity until we learn to liquidate the estate fully. But at the same time, they're reluctant to want to enforce litigation because then that will bring the bonds into question, which I proved with my car insurance case. So the bonds are the answer for us in order to protect ourselves until we learn to crack the code with liquidating the estate and moving everything into the private. Okay, and this is something I've gone through before and proved with my car insurance case. And I've been actively A4Ving bills, and they've kind of just been automating the reminders but threatening enforcement, but they haven't enforced. Okay, so because it's bringing up this kind of precarious situation they're in, reluctant to perform and honour these set-offs because we're still in a trustee dissonant capacity, however reluctant to actually enforce litigation, because then that will bring the bonds into question. And that's exactly what happened with my case here. They tried to sue me for not having so-called insurance, but I had a bond held with the Department of Transport, and in the end, after back and forth, after they tried to prosecute me, they issued a letter of apology and rescinded the fine and the points on my license. And here's the proof, okay, which otherwise reveals that the bonds are the secret weapon for us to indirectly access our said KB trust until such time we learn to liquidate the estate. Okay, and that's why there's a lot more room to kind of gauge and play with in regards to that, setting your estate up and have an extra protection, but also trying to get them to perform when you have the set off and indemnity bonds in. Okay, because everything in bankruptcy has to be bonded, licensed, and insured. All right, so that's a necessity before you actually go after doing anything in relation to trying to combat these guys, is that you must have your security agreement, you must have your UCC and PPSR filing done, good understanding of the UCC and securities, how to issue them, control them, and perfect them. And then you could go into issuing your bonds and then assign them to those individuals who are holding the bonds, and then obviously control them on the PPSR, UCC, and then after that, good understanding of bills of exchange, and the world is your oyster. Okay, and just simple letter writing, understanding the postal road mechanics, what registration is, retaining legal title when you register things yourself under your own hand and seal. And yeah, everything that I basically go through on my course is going to lead you to become an elite sovereign master of the game down here, with everything that is set up on this two-dimensional paper realm of fiction personas, contracts, and wet ink, just merely thought up in the minds of men and women, and well, inevitably I think ETs that men and women are helping to administer. So the international creditors deposited something of value in the trust in order to establish it in the account. The public trustee files an election with the High Court in order to attain letters of administration to administer your estate, the placenta's estate. All proceeds from your estate are invested and accrue in trust for periods of 2 to 6 and 25 years, where they move from the unclaimed monies fund to the consolidated fund, treasury investment suspense account, and the funds and special funds that effectively forms the Commonwealth. So we have the administration, the performance of the executive function of the government as opposed to the judicial and legislative functions, and we have the management of the affairs of a bankruptcy and the management of a deceased estate by a person duly authorised to act as executor or administrator, depending on whether the appointment was made by will or by the High Court. Okay, and that's what we find the government's acting in a state of bankruptcy, but they're also there administering our deceased estates, hence why they run an administration. And here you can see in Queensland, this is what I dug up with my research, how they're gaining control, right, which is the Public Trustee Act 1978, Section 31, appointment of public trustee in the place of existing personal representative. And you've got the subsection here, 1ABV, states that where the deceased is intestate, or where the deceased left a will, and no person has applied for probate or letters of administration with a will annex within a period of 3 months from the death of the deceased, the public trustee may apply for and be granted an order to administer the estate left unadministered. Okay. And then subsection 4 states that on an application under subsection 1 or 2A, the public trustee shall be entitled as of right to an order to administer. Like I said before, if you're making these claims, you've got to prove where it says in their statute that these guys are doing this when you want to go to court in order to, prove your case and make your claim. So burden of proof is always on the claimant. Okay, so that's where it says after 3 months, because obviously this entity is a dead bastard, died without one intestate because it's a placenta, and yeah, they came along and claimed it under this law, this rule. So we have more definitions of administration just to re-emphasize, what the governments are doing. So administration here from Bouvier's Online is when a business can no longer meet its debt obligations, which is technically true. Okay, then administration trusts the management of the estate of an intestate, a minor lunatic, an habitual drunkard, or other person who is incapable of managing his own affairs. And that's the presumption, unfortunately, that they assign to us. So they presume that we're dumb enough to step up as agent and surety for all of their debt. And we have administration from LexisNexis is the administration involves collecting the deceased assets, paying debts, and distributing the balance of the estate to the persons beneficially entitled to it. But because we've not made a claim and they've declared that entity dead, I presume we're dead and idiots, incapable of managing or making any claims or having any standing, they take it all for themselves. After obviously it's held in the unclaimed monies fund after a certain time, then people claim on that, those who know how. Then obviously the management of a deceased estate by a person authorised to act as executor or administrator, depending on whether the appointment was made by will or by the court. Okay, so they claimed it through letters of administration because that entity died without will intestate. And then we got even more under LexisNexis. Okay, administrator is an appointment of an administrator will be made if the deceased dies intestate. Letters of administration are usually granted to persons interested in the estate of the deceased, and the public trustee may be appointed as administrator. Okay, now, unlike the office of an executor, the office of an administrator is not transferable by representation. Okay, however, what I found with what I'm using in court is the following act. Now, just get up. The Succession Act 1981, Section 52, the duties of personal representatives, and I think it's actually this one here, so it's 1981, Section 6, jurisdiction, power to revoke a grant of letters of administration and grant probate of a will. Okay, and that's otherwise what the Supreme Court has the powers to do, and that's obviously what we're seeking, what I'm seeking to get done, given this setup that has happened with the birth of my placenta. The registration of the placenta. So we have an organisation that calls itself the government that is administering deceased estates as the placenta died without will intestate by virtue of the language, definitions and the forms and procedures and laws surrounding our birth. The living son and daughter identified by a given name has been made surety and security for the national debt by combination to the ends league of strawman. The strawman is an agent in commerce created for our benefit in order to interact in their corporate world, or rather drag us into their underworld. However, this entity is a vacant position and it does need an agent to represent it. Through subrogation and us answering to that name, we play the role of trustee in their commercial theatre under their acts, where we must act out the trustee's role or face penalties for not following the letter of the trust indenture, which is their legislation, statutes and acts. And there's that basically trustee de centor definition and capacity that we're in. That explains that. So trustee always has to pay. The Crown becomes the executor, beneficiary and administrators, as the rightful living heir and beneficiary, us, have been paying surety to a dead bastard entity and operating under presumptions of law and not claiming our correct status and standing as principal beneficiary, where no distributions can be made as the beneficiary is assumed and presumed dead. Thus all property is made bona fidentia and devolves as skeets to the Crown. Okay, the Crown can be seen as the head of this corporate trust structure, which acts in right of any and all instrumentalities beneath it. Thus, it's like the Joker in the deck of cards, and there's that famous line out of the song, and while the king was looking down, the jester stole his thorny crown, the courtroom was adjourned, no verdict was returned. Thank you, Bill Turner. Okay, and so, yeah, all of these folks are agents for the Crown, and they've all sworn to uphold statute. Okay, so there's nowhere they can go. When you say that and remind them of that fact, they must follow the trust indenture. Okay, and so within their acts is the remedy that we can rely on in order to provide evidence of what has been set up and what we can claim back. Okay, it's quite simple. Through the will of the strawman, because all property may be disposed of by will. All right, and that's what I otherwise emphasize here. My case, which I think actually I put on another note. All property may be disposed of by will, and you'll find that in your local legislation everywhere because it's a universal law, international law. So what many don't realise is that most every government in the world is operating as a debtor on a Chapter 10, 11, 12 bankruptcy, where the creditors, the central bankers, have indebted them, the governments, and made them default, which resulted in them demanding their pound of flesh, which under a Chapter 11 bankruptcy has given them the right to restructure the administration to suit their needs, which is mainly raising revenue to ensure the debt is being serviced through taxation. Most every government lost control of issuing money debt-free to fund itself and had to go to a privately owned central bank that loaned money to them at interest, which was created from an account of zero balance from nothing. In order to ensure the government can still operate, the creditors took legal title to all instruments registered and administered by the government, which included, but not limited to, registration of births, cars, goods, lands and houses, basically having a security interest in all of the nation's GDP and taxes, as the governments, as debtors, had to pledge that as security and collateral to stay in business and service the debt and keep the creditors happy. So it is no coincidence that the rise of central bankers in the 20th century was also the century of war and increased taxes. Okay, taxes are the main revenue tool that ensures the debt is serviced. So in bankruptcy, as I said before, everything is insured, bonded and licensed. This is why everything has to be underwritten, given ratings and permission to do things under license. And I've put in brackets here the insurance companies around the world, but they're all in cohorts with one another. It's one of the same banks and the insurance companies all in it together. So bankruptcy is the quality, state or condition of being without enough money to pay back what one owes, which is kind of insolvency, which is kind of also true of the governments. I mean, in the whole situation actually, because if all the debt was paid, there's only ever the principal and the money supply that is issued right through this process of credit creation. The interest is then charged on top of that. So there is actually not enough money in the money supply to pay off the principal and the interest, because only the principal exists, right? So effectively, everyone is insolvent. If you were to collateralize all the debt on a world level, international level, there's not enough money to service what's actually owed in interest after the principal is paid off. So that is true. The governments are in a state of insolvency, and they're also in bankruptcy. So two, a statutory procedure by which usually an insolvent debtor obtains financial relief and undergoes a judicially supervised reorganization of the debtor's assets for the benefit of the creditors. Okay, so you'll see whenever the central bankers, the private bankers, got the governments in this precarious situation where they were insolvent, they defaulted, so they then had to be, brought in and restructured under this bankruptcy, that all of these laws start to change and everything started to change within the administration. We start to have registration of births. Prior to, I think, 1933 in America, at least, it was all held in the family Bible in records. People, had a allodial title, etc., etc. And this all goes back to like 1066 as well, with what happened there with doing, the Doomsday surveys of all the lands, which again are just pieces of paper, administering these fictions, thinking that it is actual real land that can never be owned, controlled, or taxed, because that's created by God. You can only control what you create. So again, they just create this colorable law system in order to trick people into thinking that we're dealing with actual real assets when we're not. It's all colorable fictions of law, money, and title, right? And so, this is how they then start to creep in with all their extra statutes, regulations, which are very restrictive, oppressive, austere, more taxes, obviously, in order to service the debt, and the need to register everything, okay, and keep immaculate records of all of the assets that are being produced by that given nation. So there are two general forms of bankruptcy. This is taken out of Black's Law. Okay, we have the liquidation side of things, and two, the rehabilitation. Okay, and that's otherwise what the governments are under, rehabilitation. We have Chapter 7 of the Code is entitled Liquidation, okay, which obviously quite straightforward. Straight bankruptcy and bankruptcy often are used to describe liquidation cases under the bankruptcy laws, because the vast majority of bankruptcy cases are liquidation cases. In a typical Chapter 7 liquidation case, the trustee collects the non-exempt property of the debtor, converts that property to cash, and distributes the cash to the creditors. Okay, the debtor gives up all the non-exempt property she owns at the time of the filing of the bankruptcy petition and hopes to attain a discharge. We've had plenty of those cases to do with, individuals or corporations. But it's this one, chapters 11, 12, and 13 of the Bankruptcy Code, that contemplate debtor rehabilitation that our governments are in. Okay, so in a rehabilitation case, creditors look to future earnings of the debtor, not to the property of the debtor at the time of the initiation of the bankruptcy proceedings, to satisfy their claims. It's a hybrid, because they are looking at the property, but they just claim legal title to it. And then obviously every citizen that comes in, all the labour they produce, GDP, as well as all the taxes, is then looked at to service the creditors. So the post-petition earnings pursuant to a court-approved plan. Okay, so that's all been done. Pretty much every government, where there's a central bank, this is happening. And so insolvent, definition, Black's Law, is of a debtor having liabilities that exceed the value of assets, having stopped paying debts in the ordinary course of business, or being unable to pay them as they fall due. Okay, so they definitely have liabilities that exceed the value of assets, but they're still servicing the debt. So it's a little bit of a hybrid, like I said before, but the best way to explain it is that Chapter 11, 12 and 13 bankruptcy that these governments are operating in. So we have the trust that is set up at our birth, is managed until the age of 18, where we are meant to make a claim on that trust, and the state is the living beneficiary, where we will be entitled to distributions. This can only be done when presenting a will of the straw man, as all property may be disposed of by will. But as a result of the clandestine activities going on with the definitions, forms and procedures, in our ignorance we are presumed dead, and the government comes along and offers us another deal in the form of social security and national insurance. This gives the government's power of attorney over our estate and trust, and is a pass-through account that they use to embezzle our estate. The security offers us limited liability to operate in the field of commerce, which is a benefit, and for that benefit they will help themselves to our trust, as we have ignorantly handed over access to them while still remaining dead or lost at sea, and surety and agent for the straw man, acting in a trustee de tort capacity that these governments are at war with, okay, because it's declared a criminal, right, and it's responsible for servicing all the debt by the creditors. So the creditors come after you. So the birth certificate identifying the strawman entity is needed to open up a bank account and is used as ID verification for other government and commercial registrations. The federal government and country known as Australia and all nations operating in the system just replace, obviously me applying all this to where I was born, you just do exactly the same to where you are, where the system's being administered, is operating in bankruptcy and is insolvent, a mere debtor owing to the privately owned creditor institutions of the IMF, World Bank, et al., whose subsidiaries are the central banks around the world. Simple to prove this is, just look at the national debt calculator wherever you are on Google. The Corporation of Australia issues bonds securitized by the birth certificate to the Reserve Bank of Australia, who creates the money loan to the government on account of zero balance, which is newly added to the money supply in order to fund government. Okay, and we are able to prove that now based on Richard A. Vernon's 2014 paper, Proving Banks as Credit Creators, that no matter what loan is being issued, whether it's at a governmental level, central bank issuing it to the Treasury, the government, or at a private level in commerce in regards to a business loan or personal loan for consumer spending or asset purchases, the same process happens. It is newly created. And that's what we're going to get into now, just to go back over, revise, which I think is very important. Banks are creators of credit. Every time a loan is issued, it creates new money in the money supply from an account of zero balance. They do this by redefining accounts payable liability as a fictitious customer deposit that acts to extend the balance sheet. Banks don't take deposits, nor do they lend money. They are in the business of purchasing securities, which is your loan agreement, which is a promissory note, creating credit and taking loans from the public. Banks operate in a special type of debtor-creditor relationship with its customers, as money held on account to the customer's credit is not held in bailment, in a bailee position, not held in trust as a trustee position unless it is a trust account. Then through a constructive trust, the banker can be liable and seen as a trustee in that relationship, nor as an agent in the kind of principal-agent relationship. It is seen as a loan given by the customer to the banker to do with those funds as he so chooses in order to make more profit for the bank. Okay, the banker's duty is to repay the debt owed to the customer when a demand is made, which makes it a chosen action. Okay, and remember the two cases, C. Foley versus Hill of 1848 and Crotton versus R, 1967, that proved this fact, okay, which was taken out of Banking Law by Alan Tyree book that I found. Government regulation the world over, including academia, teaches and treats banks as financial intermediaries who loan other depositors funds and only contribute a small amount to the increase in the money supply via fractional reserve banking that happens through systemic interaction of the banks. In other words, banks are unimportant for economic models, ignoring the elephant in the room, which is banks as creators of credit that contribute a whopping 97% increase in the money supply every time a new loan is issued. Only 3% comes from fractional reserve banking, exposing the obvious subterfuge. Okay, I know a lot of this, folks, for you guys who are kind of already at this level, I know it's like flogging a dead horse, but that's the whole concept of revision and like 7 times exposure. Because each time you kind of go back over and revisit these subjects that I had to do in order to get up to this level, where I can almost, I can explain it off the top of my head and on my own 2 feet. Okay, because then obviously if you end up going to court and putting a case together, they're going to be there to prove that you can stand on your own 2 feet and verbalize this in an audit, a hearing, audio. Okay, and that's what the whole hearing came about in court, because they used to stand there to hear the case and the accounts of that individual. Okay, you can otherwise prove what they put on paper, and that's what you're gonna, substance over form. Behaviors must match your assertions. All right, and that's the true test, is to be able to embody it within the body, where you store your memory, your mind, your psyche, of all this. Okay, so rinse and repeat until you embody it, and you can explain it off the top of your head and truly understand what's happening, and stand in front of anyone who's otherwise then questioning you on it without scampering and feeling sweaty and anxious and nervous, but knowing full well what the system is, and you've got all the evidence to back it. So this is Werner's famous paper, Can Banks Individually Create Money Out of Nothing? The Theories and the Empirical Evidence, that you can download for free on Google. Just search that title and his name and it'll show up. And then this is what he found briefly. An empirical test is conducted whereby money is borrowed from a cooperating bank while its internal records are being monitored to establish whether, in the process of making the loan available to the borrower, the bank transfers these funds from other accounts within or outside the bank, or whether they are newly created. This study establishes for the first time empirically that banks individually create money out of nothing. The money supply is created as fairy dust produced by the banks individually out of thin air. Okay, so this guy single-handedly broke the spine of these guys and exposed the whole game, which is a heaven-sent absolute gem, and is otherwise, again, evidence that you can use in order to combat any loans that you might be, fraudulently serving when questioning this, okay, against the banks as to where did the loan come from? At the time the loan was issued, did the books balance? Yes, they did. Did the banks take any risk? No. Did they suffer any losses? No. Where is the consideration? There is none. Are you guys misrepresenting what you're doing? Because you're advertising you're loaning out deposits, okay, and you're taking deposits from customers. And so it exposes the whole fiction theatre of what's going on, which I'll be very surprised if someone presents this correctly, say for a mortgage, okay, and can prove, back your claims through all this proof, and ask them questions. They'll be sweating and they're going to have a very tough time in order to get the way out of you still being able to service that loan agreement, okay, whatever it's for, but specifically mortgages too, okay, because it reveals the whole fraud. That's what I mean. This is the power of knowledge, but just learning how to utilize it properly, and that will come when you embody and understand truly what's happening, and know the right questions to ask, and present the evidence and make the claim. So here you can see the accounting. So basically, this is the step comparing a non-financial corporation and a non-bank financial institution to a bank. The evidence is the same whenever a loan is issued, up until you get to the point of them discharging their liabilities, where the bank simply redefines accounts payable liability as a fictitious customer deposit, given the fact that, under banking law, seen as a special debtor or creditor relationship. Okay, money held on account to the balance of the customer with the bank to its credit is seen as a debt, okay, that the banker owes the customer as creditor in the special debtor or creditor relationship, that whenever a demand is made, the banker must serve and repay that debt, whether it's whether it's a check that's drawn, a request to make a withdrawal, an ATM, and or a bank transfer. So central banks direct the flow of bank credit creation through an unregulated monetary policy tool called window guidance or credit guidance of bank credit creation by giving orders to banks as to the amount quota of loans to issue and to whom / what purpose allocation. Okay, there's three main ones that Richard Werner talks about, which is, for productive means, which is business loans. Okay, then you have asset purchases, which is basically through financial speculation, and then consumer spending. All right, so consumer credit. The latter two obviously contributes towards inflation, because you're giving existing you're giving more purchasing power to individuals over existing assets, and so that has an inflationary effect. Whereas the former, for productive means, so entrepreneurship, innovation, ingenuity, you're creating businesses that then, employ more people, that then produce more goods, that increase the supply, And it normally happens where when the supply, obviously the new money gets injected for that business enterprise, but at the same time the supply is growing of goods and services that absorb that new inflationary money and purchasing power that's injected into the economy. And when this monetary policy tool of allocation with that in mind has been used in China and Japan, they become immensely wealthy and successful. And even in Germany, okay, through this kind of decentralized local community banking infrastructure, where there's loans directed for that purpose, primarily for, you know, productive means, these economies experienced really wealthy periods, okay, in history that Richard A. Werner otherwise writes about in his book and goes over many times in his presentations. Okay, so you can obviously see with how the economy is and what's going on with these crises and how they respond to crises, the absolute opposite, okay, an abuse of this monetary policy tool, which shows that they're deliberately driving crises, bubbles, asset bubbles, boom bust cycles, recessions, etc. Okay, and doing all the things wrong when it comes to, once they create the crisis, they can respond and actually mitigate the crisis if they respond correctly when utilizing quantitative easing, allocation for the correct purposes given the situation of what the crisis is. Okay, whether it's a liquidity freeze, asset bubble, bust, deflationary period, that again, most often than not, they exercise the wrong tactic, okay, in regards to trying to pump the economy back up and obviously support what matters most is the small, medium-sized enterprises, which reveals that a lot of the time they're only doing it to enrich the creditors and the bondholders of those institutions and small businesses and families that feel it the most during these tough times, to default and get into bankruptcy. And then obviously the values insurance covers the rest, and the guys who only benefit from that are the elite financiers who know how this system operates. Okay, so it's a bit of a zero-sum game, and yeah, it kind of ends up becoming welfare for the rich when these guys abuse this very powerful monetary policy tool. So to continue, this is otherwise what economists refer to when they say the invisible hand, without knowing it, that dictates market interaction and overall performance. Okay, this tool has been historically abused to create business boom bust cycles, this window guidance tool, recessions, depressions, hyperinflation, overall inequality in the economy. It is used to establish and maintain the scarcity economic model where all markets are rationed and the short side principle prevails. Okay, whichever quantity of demand or supply is smaller, which is the short side, will be transacted. Meanwhile, the rest will remain unserved, and thus the short side wields power, the power to pick and choose with whom to do business. Thus, what determines markets is quantity, not prices. Okay, and so really interesting snippet out of his book called The Princes of the Yen, which you can see up there on the slides. I've got a copy. Highly recommend reading. But there's the little chapter under chapter 6, page 62 of window guidance, just to give you guys where this term has come from, the kind of procedures and mechanisms involved with this. So I'll just read from the second paragraph down. And this is all taken from a perspective of what's going on in Japan at the time. So by the early 1950s, the economy was growing at double-digit rates and loan applications had become voluminous. It was around this time that the bank credit allocation system implemented by the banking department took its final shape. The governor first decided by how much total loans should grow. Then he and the head of the banking department, his hand-picked junior, Tadashi Sasaki, allocated this increase to individual banks as loan quotas. The banks were asked to present their detailed lending plans down to the names of all large borrowers monthly to the Bank of Japan. Tokyo banks reported to its Nihonbashi headquarters, others to its 33 regional branches. It's interesting, number 33. Now that's linked to Freemasonry. The Bank of Japan then adjusted the lending plans to fit its credit allocation plans. Since bank officials came to the Bank of Japan to be told virtually over the counter, in brackets the teller window, of the banking department how large their loan quota was going to be, the procedure came to be known as window guidance. Okay, and in brackets you put here the Japanese term of this is called Madoguchi Shido. Okay, so depending on where you are, this same process is going on where these central banks are. Okay, whether it's America, New Zealand, Canada, UK, Europe, Australia, okay, China, Japan, obviously, this is going on, this window guidance of directing bank credit creation, allocation, and quotas. So just to wrap up, the Bank of Japan decided the loan quotas of the large city banks first, a proportion of that was then allocated to other banks. Since the banks in turn allocated their quota among their hundreds of branches all over the country, where they were further divided and allocated to thousands of individual loan offices, window guidance was the pinnacle of a comprehensive quota allocation pyramid that pervaded the entire economy. Okay, so when this was utilized correctly post-war, Japan boomed, okay, and they became a very successful powerhouse economy, which is all based off of the post-war economy, which they kind of like were very militant as an individual race as well, which, you know, obviously aided in their success. But when this monetary policy tool is utilized, when you have a local community decentralized banking infrastructure with more loan offices, and you have a central bank wanting to, down the chain through window guidance, tell all of these banks, right, to loan for productive means, then you have at the grassroots level individual loan offices that are working with the community that know exactly what is needed, and so thus can work with more specialty, knowing that they're living there, they know the community, they know what's needed, they know the people that they're dealing with in order to set up businesses, and know what's going to make local communities prosperous going forward. Okay, so it's a tool, like I said, like a knife. Knife can be used to cook beautiful meals and feed people, or can be used to, you know, stab and cause harm. And certainly this monetary policy tool is also a tool. Money is a tool. Okay, it's a medium. It has no feelings. It isn't a person. It's just a tool. And unfortunately, it's the individuals in power that are abusing this tool and are very selfish and like causing inequality and kind of crises rather than prosperity. Okay, but there's been certain times throughout history where this tool has certainly been used for the benefit of the people when it is used for this productive means, okay, which obviously Werner highlights in a lot of his works, and highlights obviously that happening in China, Japan, and also Germany, and even under the tally stick system, you know, with the whole completely new system, that was also used to be actually quite prosperous in that Norman conquest period, post 1066, believe it or not. Okay, so yeah, it can be used for good rather than bad, but unfortunately the way it's been used, especially the last kind of 30, 40 years, it's been abused for sure. So we have here another paper published in 2018 by Richard A. Werner titled Reconsidering Monetary Policy, an empirical examination of the relationship between interest rates and nominal GDP growth in the US, UK, Germany, and Japan. He found that interest rates tend to follow economic growth rather than lead, and shares a positive correlation as opposed to a negative correlation, as is conventionally held as belief for monetary policy in economics to control inflation. Rather, the interest rate discourse is a pseudo-rationale used to entrain and gauge public opinion, keep the financial scribblers busy and regulators unchecked, whilst the real driver of economic growth and inflation is kept hidden, which is the window guidance of credit creation by the central banks. So economists all presume the following theory: markets always clear and they are efficient. They assume the following axioms when modeling and predicting the behaviors of markets. They assume perfect information, complete markets, perfect competition, instantaneous price adjustment, zero transaction cost, no time constraints, profit maximization, and nobody's influenced in any way by the actions of others, okay, which is probabilistically absolutely impossible, okay, when you actually do the calculations, which ends up being like 0.005% chance that all of these axioms hold true in the real world when economists run their theoretical models, okay, because they then assign, there's a famous Latin phrase called ceteris paribus, where all other things being equal, this is what should happen. But of course, not all other things, like all of these 8 axioms, are going to be held as equal and be fixed. They're constantly fluctuating, constantly changing. And so thus it's impossible to translate from the theoretical world of these economists to the world of practicality, especially when we have obviously the huge emitting fact of what is contributing to 97% of the money supply not taught in academic textbooks. I know I went to university to study an economics degree at Bournemouth University for 4 years, and they didn't teach me anything to do with banks as creators of credit. It was sold as banks as financial intermediaries. Nothing to see here. Banks are unimportant. It's all done through the Reserve Bank. Some of it's attributed to fractional reserve banking, but it's all to do with fiscal policy. Monetary policy just controls interest rates. Nothing to see here, and it's all smokescreen and mirrors, big clandestine pile of poo. That was a complete waste of time, to be honest. So, folks, if you want to get an economics degree, just simply read and watch this presentation, get hold of Rich Dave Werner's book and read his papers online, and you'll know more than most professors in economics. So Werner quotes Alice in Wonderland through the looking glass when highlighting the absurdity of modern economic theory, where Alice is talking with the White Queen. Alice laughed. "There's no use trying," she said. "One can't believe impossible things." "I dare say you haven't had much practice," said the Queen. "When I was your age, I always did it for half an hour a day. Well, sometimes I've believed as many as 6 impossible things before breakfast." Werner concludes in one of his lectures, which is brilliant. "Now realise that Alice in Wonderland couldn't be a good economist. She was far too realistic. But even the Queen in Wonderland, who had most practice in believing impossible things, could not be a good economist. Why? Because it is totally insufficient to only believe 6 impossible things before breakfast. If you want to be an economist, you have to believe at least 8 impossible things all the time." So the principle is only ever created when money is created on account of zero balance, and interest is charged on that principle within the money supply, meaning there is not enough money created to ever pay off the principal plus the interest. It's that kind of concept of insolvency, as the principal alone will absorb all the money in the system if it were paid off and leave nothing left to service the interest. Hence why the national and international debt continues to rise and a zero-sum game unfolds. The majority of the citizens' taxes goes toward paying the interest due on the national debt owed to the Reserve Bank of Australia, who is a privately owned corporation and creditor who has long since restructured government to serve the international banking cartel's agendas of enslaving the human race via debt servitude, as debt incumbent households do not go on strike. To add insult to injury, most all taxes do not go to fund government spending for their needs to maintain the administration, but to service the interest and debt owed to these central bankers, effectively pledging every citizen's lifetime of labour and taxes who is born in the bankrupt corporate warehouse of, insert your nation here, to serve the creditors. The borrower is always servant to the lender, as we know, Proverbs 22:7. To add even more insult to injury, the central banks do not pay any tax on the profits earned from their enterprise of loaning the government money at interest from nothing. That would defeat the purpose of the whole scheme and otherwise shows us all who is really in charge here and what taxes are used for, which is control, okay? Because they know fear is the currency of control. As I said before, debt incumbent households do not go on strike and the borrower is always servant to the lender. And so effectively the creditor-debtor relationship is just the modern term for master-slave. All right, so what is needed to fund government? Quite simple. Duties or impost on imported goods and excise taxes on domestic goods that are non-essential items is all the revenue required to run government. Now think of how many taxes beyond this have been enacted in order to raise revenue to pay off interest due on debt for a privately owned institution who loads money from an account of zero balance. Okay, so it is such a fraudulent system. And you got here Ronald Reagan's Grace Commission report of 1984 surrounding taxation, and he's quoted to say, because he knew what was going on, 100% of what's collected in regards to taxes is absorbed solely by interest on the federal debt and by federal transfer payments. In other words, all individual income tax revenues are gone before 1 nickel is spent on the services taxpayers expect from government. Okay, and the reserve, this is here. In Australia, you'll be able to find a very similar clause put into the acts, depending on where you are, guarantee it. The Reserve Bank of Australia, all central banks, pays no tax on the income it earns when loaning money it creates from nothing to the government and or selling these bonds in the markets at a discount as stated in the Reserve Bank of Australia Act 1959, which should be section 79, taxation, where it states the bank is not liable to taxation under any law of a state or of a territory to which the Commonwealth is not subject, and the income of the bank is not liable to income tax under a law of the Commonwealth, which kind of makes sense. If you understand this scheme, it defeats the purpose if they're also taxed, because the whole idea of taxing is to service the debt that these guys are issuing. So again, here to re-emphasize, this is taken out of Banking Law book by Alan Tyree. Bank and customer relationship is seen in the eyes of the law, which is a special type of debtor or creditor relationship wherein a deposit held with a bank is merely a loan you give to the bank for the banker to do with it as he pleases. Thus, money standing to your credit on an account held within a bank is seen as a debt, accounts payable liability. Okay, the bank owes you, but that debt isn't paid until such time you make a demand for it. Okay, so this is where I found out about how the courts and the legal system see banks, which again, obviously is not advertised and thus is misrepresented. Okay, banks are misrepresenting what they do. and certainly government regulation are treating, especially here in Australia, then no matter where you are where this system is being operated, they call them here authorized depository institutions, okay, which again frames them under the model of the financial intermediary. Banks are financial intermediaries, nothing else to see here, and that's what's otherwise pushed and sold in academia, in the media, and with government regulation. So yeah, they're absolutely not telling us the truth as to what is really happening. And you also have the Croton versus R case here as well, which I've obviously gone through. You can pause and read through in your own time, and otherwise use that as proof again to back your claims as to, banks, what are you actually doing? Because this is what is being proven and recorded in court. So why are you misrepresenting? Why are you not advertising truthfully what you guys do? And why the government not regulating this fact, especially when it comes to creators of credit? It exposes the whole game. So the twins in the womb, Romans 9:11, for the children being not yet born, neither having done any good or evil, that the purpose of God according to an election might stand, not of works, but of him that calleth. Romans 9:11 establishes the election made for the twins at birth, which determines whether you will be treated as either the dead fiction trustee or living beneficiary. Principal is probably a better term, and heir and sovereign successor. But we certainly have got a beneficial interest in the placenta's estate. So the twins in the womb mentioned in the Bible could also be interpreted as the live-born and the placenta. Story of Jacob and Esau. Esau was the live-born, and Jacob the placenta, representing the straw man. And I've got this all from Bill Turner's wonderful research, so thank you, Bill. Kind of makes sense. So another interpretation of this could be that the placenta stole our birthright by dying intestate, for which a trust was set up, and that trust is under administration in the name of the Father. Regardless, there is verifiable proof that by filling out the certificate of birth that is called the source document, a dead fictional character has been created in the name of the Father and of the Son, all held in trust, and the Son's birthright has been stolen by virtue of the assumptions, presumptions, and language used in the legal forms, definitions, and procedures. Okay, as the Bible says, in the beginning the world was without form, and the form was created to debase the living man and woman into plain surety and trustee for dead fictional entities and the colourable jurisdiction that governs them. Furthermore, in John 1:1 it says, in the beginning was the Word, and the Word was with God, and the Word was God. Who is God? It is the Word. The Word is what governs our body politics and is what can be used as evidence with what I have proven in the forensics of the forms, definitions of words, and registration of birth to mean something completely different than what it purports to be on the surface and at face value. The legal world has a completely different language than plain simple English, evidenced by the many legal and law dictionaries that are copyright and owned by a private corporation. So the Father's name can also be construed as being synonymous with Lord and God. Okay, the false one, as mentioned in the Bible, which represents the crown, the dead corporate one, with the Bible warning us not to use the Father's name in vain. So the Lord's Prayer, Matthew, it mentions, thy will be done on earth as it is in heaven. And it actually mentions, forgive us our debts as we forgive our debtors. Then in Exodus, thou shalt not take thy name of the Lord thy God in vain. Okay, which is basically the Father's name. So by taking the Father's name, in my case, Middleditch, I have now bound myself to the Holy Ghost, Alexander George Middleditch, okay, which is obviously the Antilegis entity. And Matthew, it says here, I will give you the keys of the kingdom of heaven. Whatever you bind on earth will be bound in heaven, and whatever you loose on earth will be loosed in heaven. Okay, so by adding the Father's name, Alexander George, the living, myself, became surety to the trust set up in the name of the Father through the Holy Ghost straw man. And that's only done through my actions and ignorance, okay, and lack of education of this fact. And so once you come into the knowledge, wake up, rise up, and present all the evidence, you should be able to find your remedy and liquidate this estate. But like I said, in the meantime, there's technologies that we use and rely on, given the bonds and everything else, in order to protect ourselves and create that separation as, secured party creditor, principal, beneficiary, postmaster general, and all these other titles, sovereign successor, heir, right, rather than surety and agent for the strong man. Okay, so we can navigate this plane a lot more safely, a lot more easier, and protect us for equity so it doesn't get siphoned off to enrich these creditors, scumbags. You create all the debt from an account of zero balance, okay, until such time we learn to liquidate the estate. So just to highlight again, this is what I put together, figure 1, for representation of this trust setup and the two systems operating alongside one another with the three entities established, which is obviously, the Father, the crown, which is my surname, which is the CKV trust that takes on the roles of executor, administrator, crown, settlor, or creator in this kind of trust setup. Then the son, which is me giving Christian name, Alexander George, identified by the source document and extract, showing the separation of the son and the father's name, who is a live born, living principal beneficiary, personal / authorized representative, secured party. You've obviously got the security agreement in play. De jure party, the only one who can give life to the trust, and the Holy Ghost, which equals the birth certificate, identifying the ens legis entity where the given name, Alexander George, my name, has been joined to the name of the father, Middleditch, and is a vacant position and needs an agent to represent it, okay, which Alexander George myself steps in as surety for and acting as trustee this on tort, and had been for a long time until I realised what was going on. Okay, so you've got the kingdom of hell on earth, public name, identifies with the name, it's in the public, applies for privileges, bank account, remains a child, dead, corporation, reserve bank, must buy stuff with reserve bank currency, perpetuates debt, always acts in ego, is an argument in dishonour, doesn't know how to play the game. As we saw, the father, the crown is the surname, CKV trust, again, that was used back in the day to identify slaves as masters of estates, had the surname, and that was what was taxed under the Norman Exchequer, okay, with the High Court after the conquest, and that was used to identify the estate, and then that surname was used to assign to slaves names to know and identify to other slave owners what estate they were owned to. Okay, so it's a master slave identifier, and that's linked to the CKV trust, executor, administrator, corporate, crown, settlor, creator. And the kingdom of heaven on earth is on the private side, okay, where we got the right identity, the born identity, knowing who we are, what was given to us. We're sovereign, must notify everyone, Christian or Muslim or Jewish, whatever your religion or faith is, doesn't matter. We're all the same. Consciousness has no colour, it has no race, it has no creed. It's the law of one. We all come from the same God source. It's just that we've been individuated in these holographic time-space arenas in order to experience space, time and matter, okay, and forgetfulness in this instance, what's been done on this planet. We're alive, treasury, okay, deals with the treasury. This is where the set-off and indemnity bonds are. Makes payment by set-off, balances the book, spiritual, peaceful, honourable. Okay, and then obviously here the son, give a name, Christian name, Jewish name, Muslim name, whatever creed you are, living, crown, live, born, alive, etc., etc. Okay, and the Holy Ghost is the birth certificate, give a name plus surname, strawman, ens legis, needs, an agent of commerce, vacant position. And unfortunately, this Trinity is more the unholy Trinity, and I'll go into this with Tales of a Self-Initiate. So it's all coming from the patriarchal creed of the fallen Anu Elohim Jehovian collective, okay, which are the backers behind the Protestant movement. The Catholicism movement of the Christian denomination faith is the Draconians, Omicron Draconians, the fallen seraphim races. And then you have Judaism is pretty much linked into the Anu Elohim, the black cube, okay, Christianity too. It all goes back to Saturn worship, unfortunately. Islam's no different with Allah, the Kaaba, and Allah is the Kabbalah, which is the Jewish mysticism of the Sephiroth, which then it goes into the reverse mathematics, but that's more of the occult subjects that I cover in my book, Tales of a Self-Initiate, and obviously on my YouTube presentations, kind of going over each chapter in that to highlight that always proves that. The Holy Trinity is at the top, is the omnipotent, omnipresent, pure consciousness of God's source that is undifferentiated, okay, it's both genders embodied before it then splits into the divine masculine and divine feminine, okay, and that is otherwise the Holy Trinity. So at the top you've got the Manu, androgen, still point, pure consciousness, particle unit, okay, of the first materialized particles that form the blueprint and the holographic time matrix that we pour ourselves into, that God source decides to individuate and give birth to itself with independence and free will. Then you have the masculine, Mane, electric, which is linked to light, oscillation, okay, and that's linked to the particum. And then you have on the feminine side, obviously the divine feminine, which is the ear rate, magnetic, sound, vibration, partike, okay, and then when you merge the two together of light and sound, you get frequency. So light is oscillation, sound is vibration, put the two together, you have frequency, and governing them all is God's source, first eternal. Okay, it's not a father. This is unfortunately the patriarchal creed passed in order to control and subjugate women here on the planet, who are the gestation chambers and the wombs in which to control the bloodlines, and that's exactly why they have targeted women and set up this whole kind of holy virgin, women are unclean, sinful, sex is sinful with the Christian faith. Muslims cover the women with burqas, and Jewish guys snip their foreskin so it desensitizes their penis. Women are to blame, the Garden of Eden with Eve. It's all method to subjugate the divine feminine on the planet in order to control them, because the fallen angelics knew they were the breeders. Okay, and if you want to control bloodlines on earth, you've got to control the gateways in which souls come in, which are through the divine feminine. Okay, so unfortunately it's all a trick. It's part of the patriarchal greed to suppress the feminine energy and control the wombs and gestation chambers and bloodlines on planet. All right, so this is more rather the unholy trinity, but it is, again, their code book. They are in charge of this planet, but there is universal law that must be accepted, and there is a shift happening of many individuals waking up and realizing this, as I have done. I had to unbind myself from the religare, which is the religion, which is the binding. Religare means to be on a boat as well, the ship, another ship to worship, okay, in the naval where you sit in the church, to give away your power to an external authority figure under the fear of God, who needs to sacrifice a son in order for you to reach redemption and salvation. Just think about that. It all goes into satanic blood sacrifice of the occult world of sacrificing the firstborn that empowers the father figure, okay, of these collective fallen entities that need to feed off of blood, sacrifice, souls in order to sustain their immortality, because they're disconnected from God's source first eternal. God's source first eternal, everything exists within. It doesn't need to sacrifice anything. It doesn't need anyone to die or become a martyr or grovel in order to reach salvation, because we are gifted with the eternal spirit that resides within our junk DNA, that if we put ourselves back together, you realize that what Jesus Christ, the true one, was teaching us and reminding ourselves of, that we are human angelic guardians of this time matrix, imbued and created with eternal life, but due to the forces of evil doing what they've done, they've captured soul fragments of ourselves down here and kept us perpetually recycled in these forgetful reincarnation loops, the Ouroboros, Mobius time wave, black hole technology imbued planets that they've captured here in a long history that I talk about in my book, in order to try and control us and siphon our energy in order to feed their immortality. Okay, so it's about time again that these governments are just extensions of the Shaitani, which are the vessels, angelic vessels in heaven. Thank you, Pierce Back, for his research in scafology, holographic culture, to prove through etymology of even our modern language for the last 10,000 years, ancient Hebrew, Sanskrit, Latin, French, etc., that these governments are a direct reflection of the mooring of a vessel in heaven down below on earth, which is perpetrating their statutes, acts, and motives and agendas, which goes into an invading army and an angelic host of these fallen collectives that are also infighting and battling for dominion amongst the living matrices and the fallen matrices that they're connected to down the black hole system. Okay, so yeah, must also address that subject, because those of you who are still giving your power away to a Father and a Holy Ghost, you're on the wrong side of the timeline, I'm afraid, and you must act and start the inner work to unbind yourself from these invisible chains that still have you giving your power away to a false, tyrannical, fear-mongering God that demands groveling and fear, and you accepting a sacrifice in order to get you to heaven. Because trust me, there are false heavens, and you do not want to go to a false heaven. You want to make sure that you come back into your own power, your own sovereignty, dispel all the BS, okay, which does happen when you activate your higher DNA strands, and you can see through all of it, just logically thinking about it. Anyone who sits and meditates on that subject of the kind of God that is written about in the Bible, Judaism, Islam, unfortunately it's all false demonic gods, okay, who are ruling under fear and dominion-based quests of Battlestar Galactica, fighting over finite resources in order to fuel their immortality and entropic artificial black holes, okay, that are collapsing in on themselves. So they need to recruit as many souls and as much energy, quanta, as they possibly can in order to sustain it. And that's their agenda. So much better to come back to the eternal truth of the eternal life and the Holy Trinity rather than this unholy Trinity. Okay, but by understanding, dissecting the unholy Trinity, we can see what has been going on in their code book that they've been following in order to dispel all the stuff that's happened on paper, as well as the spiritual binding of giving our power away to a false God under a false patriarchal father dominion base agenda and his son, unholy son. Okay, so we can come back into claiming our state of mind and spirit and soul. So we have here, the double entry bookkeeping as well, which can be analogous to the ledger system. All right. And this is where Jesus died on the cross to forgive us all of our sins. Sins equals debts. The age of Pisces was all about forgiveness. The age of Aries was about sacrifice. The age of Aquarius is all about enlightenment, truth, and love. To accept the Christ is to accept the charge in your account ledger and discharge it using your limited exemption through Christ's forgiveness of debt. That can only happen when you resurrect yourself and revive the trust, resurrect the Christ within. It's just basically all analogous to coming back on the right side of the ledger, kingdom of heaven on earth rather than the kingdom of hell on earth. And this is just looking at symbols. Okay, this is how these guys work through symbology, symbolic language. There's multiple ways you can interpret this. Okay, with the resurrection, Jesus can also go into Jupiter, which governs in astrobiology our liver. Our liver dies for us daily of our sins, of all the toxins we put in, and it's the only organ in our body that can actually resurrect itself after being near death. In regards to, it can pretty much destroy 2/3 of the liver, and it can actually regrow itself and reinvigorate itself. It's an incredible organ that is associated with Jupiter. Jupiter is Jupiter Zeus, Jesus, it domiciles in the age of Pisces. So yeah, I go into all of this with the more esoteric side of things, but also, like I said before, a lot of it all goes back to, unfortunately, Saturn worship. Saturn has a big hexagon storm on the North Pole, and if you draw a little Y in the hexagon, you can otherwise see like a cube, a 2D representation of a 3D cube, and if you flat pack a cube out, you get the cross as well. And in Islam, you have the Mecca, at Mecca you have the Kaaba, which is again another black cube that they circle around 7 times. Saturn's the 7th planet. And the rings, obviously, when they circle around, it kind of replicates the rings. And that is otherwise all connected to Saturn. Okay, so one way or another, it all goes back to Saturn, because Saturn is connected into Abaddon, which is the black hole in the middle of our Milky Way galaxy, which is what all the planets and stars within this galaxy are kind of held in a harness, entropic, finite life, death science, black hole technology harnessed net. But lucky for us, Earth is a way station to get up and out of here and back to where we originally came from before the fall, okay, which the Milky Way galaxy is actually a quantum fallout from another galaxy, Andromeda, due to interdimensional wars, that has been held hostage for a long time, where Earth is still Universal Stargate 3 that connects interdimensionally into higher gates, which is in Andromeda, for us to get up and out of here during this time. And portions of Earth's grids will be raising in vibration and going back to where it originally fell as well. Okay, so yeah, there's a split that's happening that has been echoed and kind of webbed and weaved into these doctrines that have been completely taken over and edited by the victors, which are the fallen angelics. But they're still letting us know a hint as to what's happening with the separation of the wheat and the chaff. It's just the separating of these two timelines of the eternal life, organic ascension with memory, recollecting and remembering everything of our identity and saving that, and the black hole fall timeline with the transhumanist agenda, Occupied Mars movement, Project 2025 under Trump, and everyone being led into science and merging, their clay, their flesh with clay with iron, it says in the Bible, mind with machine, their bodies with the machine, being assimilated like the Borg, and then going down the black hole full timeline where you'd be returned as space dust that would then be recycled and repurposed and used to form other identities and structures within new holographic time matrices. So here you can see the evidence again on the IDs that are issued to me from the government of this unholy trinity. I've got 2 dual nationality, so I moved to England when I was 9 years old, so I got actually a national insurance with them. That's when I was in England when I turned 18. And it's important to find in the statutes of your given nation, if you have a similar situation, that there is powers for the public trustee and the treasury to work with auxiliary administrators. Okay, so other administrators administrating the same estate. Okay, if you have moved to other nations and acquired dual nationality. So any name they address you in, apart from just your given name, is addressing the Holy Ghost, creature of law. Any title like Mr., Mrs., Miss has deplumed you of your feathers, demoted you in rank from that of master to Miss or Mr., from that of alive to dead, the real world to the world of fiction, personas and ink on paper that need actors to play out Satan's script, and be subservient to the government, which is an extension of the shaitani. The rulers of your mind is mental. And again, gubernator, government, originates from gubernator, which is Latin for steering a boat, hence why you have cabinets, etc. You get cabinets inside boats, so there's a lot of boat symbology and metaphors, okay, that goes into Pearson Back's research, especially to show that it all links into these lords and hosts in heaven, so to speak, under these fallen angelic false gods who are very dominion based, promote fear, dominion, subjugation, finite resources, scarcity, because they're coming from a place of scarcity because they've fallen and they have to feed off of and vampire off of living matrices in order to sustain their immortality, because they can't receive the eternal flows from God's source. And that's what, unfortunately, planet Earth is running mathematically. 2/3 of the Metatronic anti-Christic currents and only 1/3 Christic. But that's what the human angelic race was actually created to be, a cosmic doctor race to help with bioregenesis of fallen souls who wanted to come back to eternal life and to help heal whole planetary and star systems from the reverse mathematics. That's why it's been a bit of a war. So obviously a lot of these agreements have been taken advantage of when these guys, the fallen souls, gained more codes of the human angelic template that were coded with the stargates and grids of these special planets that were part of this universal Templar Stargate system setup in order to help perpetuate their agenda. Okay, so unfortunately there's a lot of fallen souls that over many millions of years through bioregenesis have actually gained the codes of the human form so they can take on the human mask, but their soul is certainly aligned and not originating from the eternal life Christ of God's source. They are on the side of the Antichrist. So the Born Identity, Sedekay v. Act 1666, everyone would have heard about this. Okay, shouldn't have to go over it really, but the Sedekay Trust is a person for whose benefit a trust is created, that is a beneficiary, and a Sedekay Trust has the equitable, not legal estate. Okay, beneficial interest, beneficiary, and that's who we are. Sedekay v, one who lives, person whose life provides the measure of duration of an estate per ultra v. Okay, and that's otherwise, again, section 4 is what we can rely on. That is codified in statute. They've all sworn an oath to uphold statute. And so we can, with an affidavit affirmed, we can, claim back and provide the proof necessary to back our claims in order to say, hey, look, we're not the dead placenta, we know what's going on. We are liking to liquidate the estate. So we are in possession of a will of the straw man. So the Sedekay v. Trust, I went through this in previous presentations, the history. Okay, so, just pause and read through in your own time. I'll just save time by just skipping through it. So again, just pause, read through. Which is basically how they've kind of clandestinely set things up to claim ownership and title to all the souls, property and lands of earth, with the Pope being the Vicar of Christ. And we know possessions 9/10 of the law. What's the other 10th? Title. And so we can just go through the brief history, okay, to recap the law of Mortmain. That's going to lead us to before the year 1066, the people of England held a allodial title to their land. Not even a king could take away the land for not paying tithing. William the Conqueror came in 1066 and stole the king's title and took the land off the people. From William I, 1066, to King John, 1199, England was in dire straits financially. In an effort to raise money, King John invoked the law of Mortmain, okay, the dead man's hand, so people were unable to pass their land onto the church or anyone else without the king's permission, which is modern day probate. Without Mortmain, the king would lose the income from the land he controlled, and the Vatican did not like that because the king was in debt to the Vatican. A quarrel erupted between the Pope and King John when he refused to accept the Vatican's representative, Stephen Langton, Archbishop of Canterbury, whom Pope Innocent III installed to rule England. In 1207, England was placed under papal interdict, and 2 years later, King John was excommunicado. Stephen Langton was a central figure in the dispute between King John of England and Pope Innocent III, which was a contributing factor to the crises which led to the issuing of the Magna Carta in 1215. He is also credited with having divided the Bible into the standard modern arrangement of chapters used today. King John, in trying to regain his stature, had to grovel before the Pope and return the title to his kingdoms of England and Ireland to the Pope as vassals, and swore submission and loyalty to him. King John accepted Langton as Archbishop of Canterbury and offered the Pope a vassal's bond of fealty and homage. Basically sold everyone out. So 2 months later, in July of 1213, King John was absolved and excommunicated by Langton at Winchester. Again, on October 3rd, 1213, by treaty, King John ratified his surrender of his kingdoms to the Pope as Vicar of Christ. 2 years prior, the Treaty of Verona was signed. King John, as most kings tried to no avail, to establish, as William the Conqueror did, a dictatorship. This seems to be the model to follow, and William set a precedent that all kings and queens would try to follow, or at least they would try to push the boundaries further set out in the doctrines written by the Church of Rome. The contract, Treaty of 1213, Treaty of Verona, was between two parties. The barons of England would not put up with being slaves anymore, so they took to the sword and made King John sign the Magna Carta. This act of the barons violated the principle of natural law, which rendered the Magna Carta as having no force or effect upon a contract between two parties. Pope Boniface VII, the other party, thought so, for he declared the Magna Carta to be unlawful and unjust, as it is base and shameful, whereby the Apostolic See is brought into contempt, the royal prerogative diminished, the English outraged, and the whole enterprise of the crusade greatly imperilled. How could the Pope declare the Magna Carta unlawful and unjust? The Treaty of Verona 1213 between King John and the Pope was a contract between two parties. Therefore, the agreement can only be modified or altered by the two signatories. So in 1302, Pope Boniface issued his infamous papal bull Unum Sanctum, being the first express trust and claimed control over the whole planet and effectively king of the world. Pope Boniface VIII was the first leader in history to create the concept of a trust. The first testamentary trust through a deed and will creating a deceased estate was not until Pope Nicholas V in 1455 through the papal bull Romanus Ponticus. That was when that was set up. And this is only one of three papal bulls to include the line with the incipit for perpetual remembrance. This bull had the effect of conveying the right of use of the land as real property from the express trust Unum Sanctum to control of the pontiff and his successors in perpetuity. Hence, all land is claimed as crown land. Real in Spanish is royal, so you've got real estate is dealing with royal estate. In 1666, an act was passed to set us free, should we ever understand it, and that's the Sedicary Act. As we've gone through, proof is the establishment by evidence of a requisite degree of belief concerning a fact in the mind of the trier of fact or the court. Okay, however, in Matthew 5:34-35, but I say unto you, swear not at all, neither by heaven, for it is God's throne, nor by the earth, for it is his footstool. And that's apparently, thanks to Bill Turner's research, which I kind of agree, that this is how they get us in the contempt of court in the very beginning, by swearing an oath, which goes against their good book, which states in Matthew 5:34-35 that we should not be swearing at all. Okay, so it's much better to make an affirmation, okay, and affirm rather than swear, okay, which is a confirmation, ratification, a solemn declaration that is asserted to be true. Evidence, a solemn declaration by a witness or interpreter that the evidence or interpretation he or she gives will be truthful, for example, okay, and that's exactly what I did as well. He did that advice and saw the trick involved with that, and otherwise with my affidavit affirmed, okay, and not sworn, otherwise solemnly and sincerely affirms and declares, okay, so you're not, cannot be construed as being in contempt of court, which is another trick. So we all know the Domesday Book, okay, which was the record of great survey of the lands and population of England taken by William the Conqueror in 1086. The book records the value, ownership and liabilities of the land and contains a great deal of information on the economic organisation of England at the time. The survey was undertaken to resolve disputes as to ownership of land and taxation liabilities of the Crown following the disruption caused by widespread Norman settlement. Again, if we recollect in this modern time, if we go under mortgages, good old Bill Turner's presentation, right, we know what's going on. Okay, what do we truly own? It's just a piece of paper with the title and description of the records held at your equivalent of the land registry, wherever you are, which explains the lot numbers, okay, and tax plot numbers, which are just only pieces of paper. Okay, so what do you own? Just a title deed, okay, registered keepers. We're not allodial title owners. We're just tenants. We're renting Crown property, and for that use, under usufruct, we must pay rent in the form of tax, okay? But all it is is pieces of paper. Okay, the security is not your home. It is not that piece of land. It isn't, the goods, because they can't control or own anything that you cannot create. Okay, and did they create the earth? No. So they just created this fictional theatre that interfaces and overlays the real world, and they got us to be dragged into their fiction theatre to think that all these pieces of paper are securitized and leaned against actual land and assets, okay, that have been created by God and created by us. So it's all fiction. And so that's certainly been proven. And that presentation, otherwise by Bill Turner, which you can see online, highlights that very well, okay, with bank practices and simple language. So the Norman Conquest, prior to this, is taken out of Richard Werner's interview with Robert Breedlove that I really quite enjoyed. That gave some pretty interesting information surrounding the history of taxation in the High Court during the Norman Conquest, post-Norman era, post-1066 era. So prior to 330 years ago, European laws decreed charging interest as illegal, a capital sin right after murder in the Bible. You have the double entry bookkeeping is fraud, as it increases the assets and liabilities, effectively extending the balance sheet, okay, which is money creation, is what they're doing today. The lost century of economics, Ron Paul said there is no coincidence that the century of total war is also the century of central banking, and is also this lost century for economics and century of rising taxes and centralization. Dead presidents and royalty on money, given this false sense of political credibility when the governments and royalty have no control over the money supply. Okay, the private banking cartel families do. Norman Conquest, post-1066, the Doomsday Book census done to survey lands to take account of who and what can be taxed, which were mainly the barons and lords of the estate. Did not conquer London, okay, as the money changers were there and loaned him, William the Conqueror, funds to feed and supply his army and settlement of England outside of the jurisdiction of London within the loan agreement. The City of London has power over London and England, as they can attend all parliamentary meetings with an unelected City of London representative to make sure nothing happens in Parliament and no law is passed that is against the interests of the City of London Corporation. The tax system was very sophisticated. The centre of it was the Norman Exchequer, which existed inside the Royal Treasury, which was originally in Winchester, as that was the capital of England. Back then, London as a city didn't exist. You just had the City of London and Westminster that emerged as the political London. Before Westminster became the de facto capital, it was Winchester. William had a new cathedral built and his palace built in Winchester, and in the palace was the royal treasury with the magic exchequer. The exchequer is named after the chessboard cloth that was put on a very large table, which was a giant abacus for calculating numbers, mainly taxes. In French, check is the name for chess, as in chessboard, checkerboard, hence checkmate. The tax collectors were the sheriffs, okay, the reeves, which are the counts of the shires, hence the shire reeves, which inform the etymology of, sheriffs today. They had to collect the tax. That was their duty. The honest type of accounting, okay, is the single entry accounting, which is known as charge and discharge accounting because of the Norman Exchequer. Because the sheriffs were charged, they were the accused in that court. They were summoned twice a year, and based on the Doomsday Book, there was a total amount of money they had to deliver in taxes from large landowners, the lords of the estates. So ordinary people who didn't own an estate were not taxed. The Norman Exchequer was the High Court, where the sheriffs were summoned twice a year, who were the accused in court proceedings, where they brought the money collected in taxes and the evidence of any expenditure from that collection by admitting the receipts. It was a form of accounting. It was also spoken, which forms the etymology of the word audit, which is to listen, a court of audit, where all the experts were listening and records were made. The records were written on cowskin and rolled up, as it was quite thick and could last 1,000 years. They were rolled up as a counter-check, which in French is contre-roll, the counter-roll, the check, informing the etymology of control, the counter-roll of the exchequer. Writing a check comes from the exchequer. Okay, the checks issued were the tally sticks, the split tally of notches put into sticks that created what they call in Bitcoin terminology a public key and private key. One was longer and one was shorter, The longer bit was kept in the royal treasury as the public key, the other one was circulating, and the shorter one was the stock, from German stock, which equals stick. These tally sticks were tax receipts, so when the sheriff had paid the taxes, he received the receipt, which used to prove you have paid tax to the government, a tax credit, so they could circulate as money. It also meant the government could spend without limit. There was no budget limit, and therefore there was money creation. Money is whatever is decreed legally to settle taxes, to be accepted as payment for taxes. It worked because you couldn't forge these because of the split tally. Each piece of wood was unique, like a fingerprint in the grain that could identify and match up the other kept on record in the Royal Treasury. If it's fake, let's check it. Okay, if they match, they tally. If they don't match, they foil. As the one kept in public was the stock, and one kept in the treasury was the foil. So if they don't match, you are foiled. Okay, stocks and shares come from this tally stick system. I find that very fascinating, very interesting bit of history. So governments issued these sticks, okay, which were bonds, debt, that were future tax credits they owed the public. This is where the first government bonds came about. They were stock. They were called stocks. And of course, later companies did the same and called it also stocks. The Norman period was a period of high growth because of this monetary system and money creation process that got invested into building castles and cathedrals, etc. This system allowed the government to issue debt without interest. Okay, the Babylonian system had a similar system with the clay receipts for gold held in temples, and they did lend money at interest, but realized this created inequality. So whenever a king died, all debts were cancelled, the slates were wiped clean, and this was the Jubilee. We adopted this system with the interest, but we don't have a solution to the massive inequality that compounding interest creates, as essentially you are taking from the many and given to the few who receive coupons on the trillions and trillions owed to the bondholders. So there is no Jubilee. Whereas you know who's in power, and the Queen, if you recollect, in London, has to ask for permission to go into the city of London, okay, which is basically where the bankers are. Okay, so the bankers rule even royalty and use them as agents for the system under bankruptcy, have them captured under complete control. Otherwise, we would be experiencing jubilees, okay, whenever a king or queen died. Just goes to show that who's in charge here on this planet. So direct government spending injected money into the economy, debt and interest free, that circulated and created prosperity and equality for the people. Central banks come along and captured governments to rely on them to issue money at interest for government spending. Tax is just a mechanism to ensure the profit mill keeps circulating to fund the interest during the debt held by the elite bankers and investors. We have the centralized money system with central banks with only one bank and 5 loan offices, versus decentralized banking infrastructure with thousands of local community banks, millions of loan offices looking at applications from small firms for loans equals a much better credit allocation and stable economy. Okay, and this is otherwise the battle that's going on. That there's a obvious agenda ever since the central banks have come into prominence, especially since 1933 in America, that ever since then there's been a lot of local community banks closing in Europe as well, ever since the ECB was set up and since the Federal Reserve was set up. A lot of local community banks have closed, otherwise showing this agenda and taking us away from what actually makes economy prosperous when this window guidance is used correctly for productive means. Okay, that they're obviously trying to centralize everything and only support the big institutions and businesses and cartels and industries that they've got control over in order to set up this NWO, right? So he went into this given time, with current affairs, with Trump being back in power for his second term, that the whole trade wars that was going on, okay, beginning in 2025 with the tariffs, is a patsy and scapegoat to cover up the central planner's order of shrinking bank credit creation in anticipation of the next big blowout and financial crisis. Okay, similar policies happened under President Hoover. That Trump is obviously being used as the second Hoover when he did something similar back in 1931 and the Great Depression came. Okay, so history is repeating itself. And Werner predicts that the time frame for the next Great Depression could be over the next few years. Okay, whether it happens depends on the type of monetary policy that they implement when this goes on. Like I said before, they have the power to avert any crises, to prevent it from happening in the first place. But if it does happen, they can certainly cure it very quickly without there being a crisis based on how they respond with the quantitative easing and where they inject that money, in the economy. And he predicts that Bitcoin will surge but will be wiped out by the central planners. So it's good to invest in gold and real estate. So part 2, just quickly, again, just to cover some more interesting facts, that the tally stick had notches to inform the value of the stick. The Thaler Valley in Austria, known for its silver mining, where they minted coins for circulation, which informed the etymology of the modern day dollar, apparently, which was how the locals would pronounce Thaler, like dollar. Austria married with Spain royalty, and through Spain settling in Mexico, they were using the Thaler, dollar, that stuck and became the dollar. Who were the Normans? Originally the Vikings that settled in France. They brought the English language. Normans just means Northmen, men from the north. In 9th century, Rollo Viking accepted an offer by the King of France to become Count of the northern lands of France, which later became Normandy, and the land of the land of the northern men. The first sons inherit the estate and land from these Normans, these Vikings. The second sons would join the clergy, and third and fourth sons would often join the army and become mercenaries. So William the Conqueror was a second generation Norman who went to the Pope to see what lands he could conquer for him. Once learning about the success of the invasion of Sicily by these Norman men, the Pope had ordered to take over, thus making the leader their king of that land. So jealousy and competitiveness inspired William after hearing of this. The Saxons were descendants from Germany and all German speaking. Pope wasn't happy about the way they were running things there, so they had several kingdoms, which obviously you can see the relation there of West Saxony being Wessex, South Saxony being Sussex, East Saxony being Essex, around the Greater London area. Second Crusade was the conquering of England, as the Saxons had appointed their own bishops as part of the Protestant movement, which meant all the money for tithes, etc., remained at the churches there in the land and not siphoned off to Rome, which is why the Pope was not happy, thus struck a deal with William to anoint him King of England as long as the Pope could appoint the bishops. And this obviously goes back into what we just covered with King John and the Archbishop of Canterbury, and obviously everything that happened around Magna Carta, Treaty of Verona, etc. So King William funded his crusade from the City of London bankers who were not happy with the Saxon rule. King William granted them sovereign status, that square mile, and were tax exempt. However, he kept an eye on them by building the Tower of London right on the border of the City of London to send a message to them that anything outside their boundary is his territory. How interesting. So English language, the youngest language out of all of the major languages of the world. Ruling class were speaking French from the Norman invasion. Ordinary people speaking German. And over time, a couple of centuries, the English language was a fusion of the two. Robin Hood, which is, Robin of Locksley, was a Saxon displaced by the Normans because all the Saxons lost their land as the Normans took it. He was an outlaw as he didn't accept integration into Norman society from the takeover. Robin's counterparty, opponent, was the Sheriff of Nottingham, the Shire Reeve, as he was appointed to collect the taxes on behalf of the Norman Exchequer. Interest rate policy is an alibi to cover up what really drives economies, bank credit creation, and give the illusion that something is being done to help the economy. Central banks came about originally in every country as a cartel for the big banks. Set the right incentives and policies in the first place and you don't need a bailout. In the UK, 85% of bank credit is for asset purchases, not national income, productive GDP. European Union modelled on the Soviet Union, both claim they run a democracy because they have a parliament to pass laws. However, all the laws were written and predetermined by the unelected Politburo, a rubber stamp parliament, as the parliamentarians have no power to propose any laws. All the laws are written by the unelected European Commission. Germany is still occupied by the US. It doesn't have a peace treaty, no constitution because it's suspended since the occupation of foreign troops, and it's still an enemy country in the UN Charter today. So Germany had no standing to challenge US with their abuse of the Bretton Woods Agreement, but France did, and that's what triggered the response by, I think, President Nixon at the time, with wanting to create the petrodollar when he made the announcement of defaulting on the Bretton Woods Agreement and sending Henry Kissinger over to Saudi Arabia to make that secret 50-year deal to convince them and the oil cartel with Saudi Arabia fronting to sell oil in US dollars. So the US dollar demand was kept in check once obviously France was the first to call out America with what they were doing in regards to their bank credit creation. They weren't holding the US dollar currency fixed to the amount of gold that they held in reserves. They were printing it from an account at zero balance. Then had to make a move to mop up the demand for more dollars by backing it against oil, making sure that all these OPEC countries are selling their oil in US dollars, which is why if you often see as well a lot of where these countries like Libya, Iraq, Iran, they all decided to change the monetary system and start selling their resources, their rich resourced lands with a lot of oil reserves in their own currency. As soon as they start kind of wanting to plan and implement that, then we all of a sudden found America going to war with him under a red herring guise. If they couldn't take them out with their jackals in the CIA or a coup d'etat, that they had to create a reason to send troops on the ground and basically implement a regime change and insert someone that was more compliant to the secret team, which is the CIA. If you read L. Fletcher Prouty and then Confessions of an Economic Hitman by John Perkins, kind of reveals all that stuff going on. And going back to the US dollar, the symbol, the S with the two stripes, used to actually be a U. So it used to be an S and a U, which identified a unit of silver. Okay, that these paper receipts were for, held in the reserves of these bank depositories. Okay, dollar was actually a unit of silver. Then over time, as they were debasing everything, they rubbed out the bottom of the U, which formed the two lines going down the S. Okay, and then got rid of the second line as well, once everything became even more debased. And that's kind of like echoes of the history of the origin of money that used to be based and backed by silver, for instance, for the dollar, and also gold certificates that were then used. And that's when the kind of first fractional reserve banking started to come about with the money changes. And obviously they got to the point now where it's just created from nothing. It's backed by nothing apart from our full faith and credit. So interesting bit of history there, quite a good, few tidbits involving courts and the high courts and taxation and the tally stick system as well, which is actually very successful. And what was going on during that most salient time in history, and how prior to 1066 we did have a allodial title, but after the Doomsday, they all claimed it's crown lands, real estate, royal estate, under these fictional titles with these surveys and plots and tax plots, which is all held at the land registry, which is just colourable pieces of paper, managing colourable titles under the fiction guise and illusion that it is actually secured against real land and assets when it's not. If you want proof of that, like I said before, Bill Turner's presentation here proves that it is all just deeds of title, and all they have is a piece of paper held on record that we're all tricked into thinking is secured against the assets when it is not. So you can't prove that they created the land, nor the house for that matter, right? So it's just all fiction theatre. So all property may be disposed of by will. So we have an entity that has an account that we have a beneficial interest in, as we are the only one who has given life to this entity and trust set up in the name of the Father, as it was our born event that gave rise to the placenta, which they used to create this entity, where we have an absolute indefeasible right and interest in it as living heirs to this trust, as we are the only ones to give it any value. So how do we collapse this trust and come out from amongst them? We need a will written in the name of the straw man, designating us as the sovereign successor, heir and beneficiary to the trust, appointing the Governor General as executor/personal representative. All property may be disposed of by will. Search for this in your government legislation. Here in Australia, this is codified in the Succession Act 1981, Division 2, making a will, Section 8, property that may be disposed of by will. Then we have the Succession Act 1981, Section 52, declares the duties of personal representatives. And I possess a will for Middleditch Alexander George, which has the Governor General appointed personal representative, as you can see here, is testifying in the will of the straw man that I drafted up. And we have the Succession Act 1981, Section 6, jurisdiction. Power. The Supreme Court has power to revoke a grant of letters of administration and grant probate of a will. So you may want to look at putting together a claim and statement of claim to sue the Crown if the Governor General does not want to accept his or her role as personal representative when you request privately to have the estate liquidated according to the will. I'm currently doing this as the Governor General ignored my private request and have submitted a case to the Supreme Court that originally got refused without leave of the court by the registrar, okay, because he deemed it as being vexatious and frivolous when it wasn't. Obviously, they're trying to play plausible deniability and silly buggers. So I'm now applying for leave of the court to commence proceedings against the Crown. This is me trying out having this process honoured. This is with the Supreme Court, okay, and then backup plan is that I've got an appeal to the High Court, which is where I believe, ultimately the remedy does lie within that Bill Turner vouchers for. That High Court is where you should be going with this. But I'm going in under the Succession Act that these guys at the Supreme Court level do have power to revoke grant of letters of administration, which is obviously what we decoded during the forensics and the forms that had happened with this estate of the straw man, and grant probate of a will that I'm in possession of. And they all taken an oath and sworn an oath to uphold statute, and they're all agents of the Crown, so they must follow suit. So we need to have a case open in the court in order for them to accept filings. This way I am able to lodge my documents with the court and later appeal to the High Court if the Supreme Court want to play plausible deniability in order to try and have this process appeased. I will now go through my case and show you guys my documents that will help highlight our situation and give you an idea as to what you might want to research and try out when doing the forensics on the forms surrounding your birth and having this process appeased yourself when gathering and presenting all of the evidence. Please do not copy directly, but draw inspiration from this, as my documents are already lodged in their system, so they will know if you copy and paste them from me, and will have a field day with you if you truly do not know what it is you are doing and cannot back what's on paper on your own 2 feet off the top of your head with how all this is set up. Okay, so as I've been showing you folks what I've been working on, let's go through this now, because sharing is caring. And I think there's going to be a need for more of us to put pressure on these folks if you really want to make this world a better place. So here's my original claim to the Supreme Court of Queensland. Okay, and the plaintiff claims the full amount from the estate of Middleditch Alexander George, and that number is obviously on my birth certificate as we've gone through, and all profits made since its inception, all court costs, amendment of the record. And I also wanted to claim 1 billion in damages. Okay, and why not at the same time ask for political and monetary policy reform? Maybe biting off more than I can chew, but had all the evidence put together to prove the fraud and trying to put pressure on these guys to make change. So I posted this with the statement of claim that we'll read through, which again just kind of highlights everything that I've done with the forensics and the forms, but put in a format that the courts can accept, okay, on a statement of claim. So the claim in this proceeding is made in reliance to the following facts. At all material times, the plaintiff, myself, was born in Brisbane, etc., live-born, flesh and blood, sentient human being of the male gender, having substance and weight on this earth, who is of sound mind, of age, numerate and literate, non-combatant, non-belligerent, and peaceable. Okay, the defendant is the Crown, which acts in right of any and all agencies, including but not limited to the state of Queensland. Okay, so I opted to go at the Crown acting in right of the state of Queensland in this instance. All right, and the Crown can act in right of any and all instrumentalities beneath it, and everyone who's taken an oath of office working with the government and these agencies are otherwise agents for the Crown too. So again, I was re-emphasising, what I found during the forensics and the form. So on the 26th of February in the year of our Lord 1989, around 5:30 p.m, the plaintiff, a healthy sentient incarnate human being of the male gender, given the name Alexander George, was born alive on planet Earth from the union of the parents, from my mother and father, their full names, in the organic God-created geographical natural region of Terra Australis with GPS coordinates, otherwise described administratively as the Mater's Mother Hospital, South Brisbane, in the state of Queensland of the country Australia. The plaintiff was born along with the placenta, also known as the afterbirth. The plaintiff was born in the delivery room and later whisked off to the ward. Okay, the definitions of delivery and ward are as follows. Delivery, the transfer of actual constructive possession from one person to another. Bailment in relation to chattels, the transfer of possession of a chattel from one person to another, as we've gone through before. Ward, a subdivision of a local government area. On the 4th of March 1989, the plaintiff's father filled out a form titled Certificate of Birth, which was signed and lodged with the Department of Registration of Births, Deaths and Marriages in the state of Queensland. So I did it chronologically. Okay, so this, for you folks who want to go through this, get hold of all of your documents surrounding your birth registration, do the forensics on them, and then list it how you're seeing it here chronologically. Certificate of Birth form shows in the top part, under the heading child that the plaintiff was given only the name Alexander George. The definition of child and birth, according to births, deaths and marriages, as we've gone through, birth means the expulsion or extraction of a child from its mother. Child includes a stillborn child. There is a legal maxim, as we've said, that inclusion one thing excludes all others. The plaintiff's father, not knowing what he was doing or possessing full knowledge of the definitions and the form and procedures when registering the birth, even though the plaintiff was born alive, filled out the certificate of birth form and duly signed it as an informant, which certified that the information shown on the form is correct for the purpose of being inserted in the register of births. It was the will of the parents to register the plaintiff in order to receive the benefits of state citizenship. However, the definition suggests a different outcome resulted from what was intended, thus resulting in a unilateral mistake where the plaintiff was effectively given a criminal charge and declared as stillborn given the definitions. Okay, and we've gone through that. Informant means a criminal. Person who lays an information in respect of a criminal, and information is the allegation that a person has committed a criminal offence. Again, revealing the subterfuge being used, lack of full disclosure, intent to deceive and discrimination. Okay, by virtue, point 11, by virtue of the plaintiff's father filling out and lodging the certificate of birth, the registrar, by entering into his book, entered a stillborn in view with a criminal charge that resulted in the birth certificate being issued and registered on the 4th of April 1989 with registration number 1989-5249. The birth certificate created a new name titled Alexander George Middleditch, in which the name of the plaintiff's father's surname, Middleditch, was joined to the plaintiff's given name. A maxim in law states the addition to a name proves or shows minority or inferiority. Okay, but adding the father's name to the given name, an inferior title and rank has resulted. The extract from birth entry evidences the entry into the book of the given name and son, with that of the name of the father's surname. The birth certificate also displays the use of the word child and informant, which carries over the definitions in which this certificate identifies this entity as a stillborn endowed with that will intestate, be with the criminal charge. Okay, the plaintiff's birth certificate is printed on security stock paper, which implies this entity has been made marketable and a security for the national debt. Remember, all of this, every claim that you're making has to be proven. Okay, so the burden of proof is always on the claimant. So I've got here, waiting, ready to go when I get my court case confirmed, date of my hearing to seek leave to commence proceedings, that I've got all of my documents, okay, IDs to show the unholy trinity. I've also got the LexisNexis, whether they'll let me in with a LexisNexis dictionary, we'll have to wait and see. But it's otherwise in the affidavit and the statement of claim. Got all the documents here, so the source document, right, birth certificate copies, so, it's all there, it's all proof, so I can prove it. So I'm not, where I say, you can make statements, right, from the affidavit upon belief, okay, which can later be proven based on the presumptions that it probably is true, okay, but a lot of what you need when, going through this is hard-hitting facts, right, and this is otherwise, a copy of my claim, statement of claim, affidavit for the exhibits, and my originating application to seek leave of the court to commence proceedings. Okay, and I know they're scoffing a little bit, and they're panicking because they know what I'm coming after, and it's well put together in my opinion. I've done my homework, I'm not just copying and pasting. So the registration number, the plaintiff's birth certificate is printed on security stock paper. Again, when you go through and you can see on the back it is actual security paper. That's what I kind of mean. You've got to prove all this stuff, which implies this entity has been made marketable and a security for the national debt. Again, proven within their definitions. The registration number 1989-5249 signifies the year of birth, 1989 being the first part, and the second part representing the number of the child being birthed into the system for that given year. Thus, this entity was the 5,249th child to be entered and registered to the bankrupt Australia Corporation in the year of 1989. The registration of the plaintiff's birth with the births, deaths and marriages created a juristic person ends league as crown entity under statute known as Alexander George Middleditch, and any and all variations of said name which has been made security and pledged as collateral for all the national debt. This entity is created off the back of declaring the placenta as stillborn, with the plaintiff tricked into acting as surety and agent for, in order to charge this entity in the realm of commerce and act as a transmitting utility. And I put there a comment revealing the nature of this system being deceiving and misleading at its very roots. 19. When the certificate of birth application was completed, the plaintiff had an account set up with the Foreign Siders Trust, commonly referred to as a SETI KV Trust, in which something of value was deposited in there as res by the international creditors, IMF et al., which has been invested, rolled over and accrued throughout the plaintiff's life. after 3 months had passed since the registered birth of Alexander George Milodich, and the definitions in the forms, meaning this entity was declared a stillborn, who died without will and testate, the public trustee claimed the right to administer the estate through letters of administration as codified in the State of Queensland pursuant to Public Trustee Act 1978, Section 31, appointment of public trustee in the place of existing personal representative, subsection 1ABV. You'll be able to find an equivalent no matter where you are. Okay, just search legislation online, use Google or ChatGPT, very easy. The Sedicavy Act 1666 also presumes and assumes the death of an individual in order for property to escape to the Crown, as it states in Chapter 11, 18, 19, an act for redress of inconveniences, etc. You all know about that. But then if the supposed dead man proved to be alive, then the title was revested. Action for mean profits with interest, but there in Section 4, as I commented, it's an act for redress to rectify this administrative mistake that the plaintiff is entitled to. So the estate trust of Alexander George has been made bona fide and escated to the Crown, given the definitions of the forms and procedures surrounding birth, as well as codified in statute, as they, some missing T there, statute, as that entity died without will and testate, and that estate has since been claimed and administered by the government, which has all resulted due to a lack of full disclosure and intent to deceive that the plaintiff is entitled as principal beneficiary and heir to that estate. Pursuant to the Public Trustee Act 1978, okay, subsection 99A, Public Trustees Register of Unclaimed Monies states that up to 25 years of plaintiff's unclaimed money from the estate are accounted for, and after 6 years, the unclaimed monies held on account are transferred into the consolidated fund. The plaintiff's money is kept by the treasurer in a fund of the trust in special funds called the Treasurer's Unclaimed Monies Fund. After 2 years, the funds are transferred into the consolidated fund pursuant to the Financial Administration and Audit Act 1977, Division 10, Unclaimed Monies, Treasurer's Unclaimed Monies Fund, 46, subsection 1, 3, and 4. And this is where, obviously, prior to putting this together, I've made multiple attempts to try and have things amended based on the evidence I collated, okay, to try through private administrative means to get this appeased and remedied, but that got ignored. So you can certainly, if you have done this, it's much better to try and prove on paper, send registered post, that you're asking these guys politely, honourably, to have this respected in regards to your request. And if they don't, then you can use that as evidence as well in your statement of claim and with your affidavit attached with exhibits that you could admit into the court to prove you're acting honourable and these guys are dishonourable, okay, which then again you can, charge being wronged for, okay, not suffered damages, because that also means that you allowed damages to happen, but I think the correct term is you've been harmed and wronged, okay. So yeah, that's where you can almost put in a claim for so-called damages, but for being harmed and wronged is the correct term to use for that. So in a letter dated 30th of August 2024, sent registered post to the Treasurer, Attorney General, Public Trustee, Governor General, the Governor of Reserve Bank of Australia, the IMF, and the Commissioner of Taxation, the plaintiff requested status amendment and fair settlement as beneficiary from the Sedicavy Trust, set up in the name of the father, but had received no response or actions to appease the request. The plaintiff sent in all evidence to appease this process pursuant to the following acts. Okay, so now these acts are pretty much what I'm relying on in order to get them to perform. Okay, that I've done my homework with under the state of Queensland. Okay, so depending on where you are, you can use this as inspiration based on where you were born and where you're trying to have this process appeased. Okay, that we will go through some of them in a little bit more in depth, I think, with my originating application. Okay, to otherwise see how it's applied to the situation that you might want to consider. And there might be other ones out there that I've not come across yet before or as yet, but I thought this was sufficient for me going through what I could find that related to my situation that I can rely on to, say, hey, look, this is what you guys are saying that I'm relying on, that you should be performing and offering the remedy through to have this process appeased. So the plaintiff later wrote a letter to the Acting Governor General, Sam Mostyn, dated 30th of January 2025, sent registered post in the matter of will upon the demise of the Crown entity, okay, which is my straw man, in order to liquidate the estate, as the Governor General had been appointed the executive for the Crown created entity, showing the plaintiff as successor and beneficiary to the estate, the particulars of which was to liquidate the estate, open a private bank account in the name of the plaintiff in his private living capacity and distribute all assets into that account. Plaintiff has since had no response or actions taken to appease the process. And then I go on, the plaintiff has been incorrectly acting as trustee de son tort and surety for the trust estate of the straw man, and seeks to have this rectified where the plaintiff can operate in commerce with the correct identity. When the plaintiff was 9 years old, the plaintiff's family moved to the United Kingdom, where the plaintiff attained dual nationality. When the plaintiff turned 18, the plaintiff applied for and received the national insurance number in the United Kingdom with the account, in the name of the straw man, or capitis diminutio maximum. As you know, it's kind of nom de guerre, identifying the dead corporate entity. So this national insurance application gave the UK government power of attorney to continue accessing the plaintiff's trust and estate, and acted as a pass-through account for them to embezzle the plaintiff's estate without the plaintiff having full information or disclosure of these activities. The following acts grant powers for Australian agencies to work with foreign ancillary administrators. Okay, so this might be a key one for those of you like myself who have dual nationality and might have, registered with foreign governments that are different from the place of your birth, where you might have things being administrated. So here in Queensland is codified under the Public Trustee Act 1978, Section 55. Public trustee may pay over to principal administrator and receive property from ancillary administrator. Subsection 2 gives powers to the public trustee to work with and receive proceeds of any assets that may have been established outside of Queensland and that are being administered by that foreign estate by an ancillary administrator. And the Public Trustee Act 1978, Division 4, authority where other jurisdictions involved, subsection 77, the reciprocating state principle. Okay, basically gives them powers to go over to England, the United Kingdom, and anywhere else where my estate is being administered, right, in order to have this process appeased. The entity on the birth certificate, Alexander George, Mr. Alexander George, again, any and all variations of this name, has been used to acquire and apply for all IDs, passports, licenses, registrations, and bank accounts within the system of commerce, and has been used to incorrectly identify the plaintiff as surety for a stillborn who died without a will intestate, imbued with a criminal charge, and made security for all of the national debt. All of the plaintiff's government-issued IDs have the given name, Alexander George, separated from the name of the plaintiff's father, surname, Middleditch, either by double spacing or entered into a different row entirely, evidencing this bifurcated title set up in the name of the father. The federal government and country known as Australia is a private company operating in Chapter 11 bankruptcy and is insolvent, a mere debtor, owned to the privately owned creditors institutions of the IMF, World Bank, Intel, whose subsidiaries of the central banks around the world, hence why they run an administration and have been restructured by the creditors. See the national debt as evidence. The Corporation of Australia issues bonds securitised by the birth certificate, its citizens, lifetime pledge of labour and taxes to the Reserve Bank of Australia, who creates the money loaned to the government on account of zero balance, which is newly added to the money supply in order to fund government. Okay, I put it in here. See Richard A. Verner's 2014 paper titled Can Banks Individually Create Money Out of Nothing? The Theories and the Empirical Evidence. And what you'll find is my affidavit is basically kind of mimicking all these claims, because I'm obviously affirming this under a solemn declaration, and then with it admitting the exhibits as evidence, okay, to be admitted into the court to back these claims. All right, but the statement of claim is just like a clean document that's just laying forth your claims, and the affidavit is kind of then providing the evidence, stating the facts again, but then providing the exhibits and references to the exhibits that you're admitting with it to back the statement of claim, which we'll go through. It's all part of this document, 24 pages. The principal is only ever created when money is issued on account of zero balance, and interest is charged on that principal within the money supply, meaning there is not enough money created to ever pay off the principal plus interest, as the principal alone will absorb all the money in the system if it were paid off and leave nothing left to service the interest, hence why the national and international debt continues to rise and a zero-sum game unfolds. The main purpose for this is to control through finance and economics the population where the short-side principle prevails. And I just quoted some passages in the Bible, all referencing the condemnation of charging interest as it leads to exploitation and inequality, especially if you don't have a jubilee to wipe out the debt and start again, which is what they actually did back in ancient Babylon, and for quite a long time, up until the private bankers took over and obviously didn't want that to happen. So the majority of the citizens' taxes goes towards paying the interest due on the national debt owed to the Reserve Bank of Australia or any bondholder it is sold to in the secondary markets, who is a privately owned corporation and creditor to Australia, making income tax a fraudulent scheme used to fund bondholders that the government does not disclose to its citizens, rather fraudulently misrepresents taxes used to fund government. And the Reserve Bank of Australia pays no tax on the income it earns when loaning money it creates from nothing to the government and receiving the repayments on those loans and or selling those bonds in the markets at a discount. As stated in the Reserve Bank of Australia Act 1959, section should be 79, taxation. The bank is not liable to taxation under any law of a state or of a territory to which the Commonwealth is not subject, and the income of the bank is not liable to income tax under a law of the Commonwealth. So you can see how this statement of claim is pretty much modelled off of my presentation that I did. So my presentation was modelled off of me gathering the evidence and everything that I wanted to collate to put forward in something like this. Okay, so it's very much mirroring the presentation that we've just gone through, but otherwise showing you how you can present this kind of information when you go through doing the same process of the forensics on the forms for yourself. If they're not willing to appease the process privately, they can certainly then admit into the court and see what they do. So government regulation the world over, but here in Australia through Australian Prudential Regulation Authority, recognises banks as authorised depository institutions when in reality they are creators of credit and do not loan other depositors funds from reserves held within or outside the bank. They are in the business of purchasing securities and taking loans from the public in a special type of debtor or creditor relationship. They do not take deposits and they do not loan out money, showing the fraud through misrepresentation. So yeah, and then obviously see Richard A. Verner's 2014 paper there. Okay, the Basel III Accord has no use in properly addressing banks as credit creators. Thus showing the whole regulatory industry surrounding banking is deliberately misrepresented and misleading and avoiding reality of what banks are. That's true. The economic theory is being propagated in academia, which then forms the professional opinions, debates and models used to influence regulation and monetary policy, has deliberately been doctored to accommodate the financial intermediation theory and or fractional reserve theory of banking that only accounts for 3% of the increase in the money supply, whilst neglecting the reality of banks as credit creators, where 97% of all money in the money supply is created whenever a new loan is issued by the bank, which is controlled via window guidance by the central banks, thus being the main cause for inflation and business boom bust cycles when abusing this tool. Okay, throughout history, it is clear to see this monetary policy tool is mostly abused by the central banks, with no party in government offering any resolution with this main issue. Thus, the plaintiff has no options but to stop contributing to this fraud and seek relief by coming out from amongst them, which is mentioned in 2 Corinthians 6, 17 and 18, as the plaintiff does not want to help fund and be a part of these sins and crimes against humanity. And last but no means least, point 42 of my claim, money is drawn on account of zero balance every time a promissory note is purchased by the bank, who then reclassifies the loan within accounts payable liability as a fictitious customer deposit in the double entry bookkeeping system, which acts to expand the balance sheet and add new money into the money supply, meaning at the time any loan is issued, the books balance and there is no debt and no risk taken by the bank, evidencing no loss, okay, nor consideration. So see Richard Verner's paper again. Okay, so just listen here at the bottom, the plaintiff claims the following relief: fair settlement of the full amount of the estate of the straw man and all profits made since its inception to be determined, assessed, a private bank account set up in the plaintiff's name to receive full settlement from the estate as advised in the will, amendment of the record to reinstate plaintiff's living private tax exempt sovereign status to be recognised as such within the system, with any and all forms, IDs, procedures and instructions made known and issued to appease this process, damages to the value of 1 billion Australian dollars for being subject to discrimination, used as chattel to plume to my status, rights and property, fraud, willful intent to deceive, misrepresentation, lack of full disclosure, false and misleading statements, deprivation of rights under the colouring of law, estate embezzlement and crimes against humanity, all court costs and fees, and obviously put in also the truth to be told and full disclosure to be given to inform the citizens so they can decide whether the central planners can abuse economies, steal their sweat equity, deprive them of their rights under the colouring of the law, and continue on their clandestine agenda to enslave the world and keep people in peonage. A jubilee. Monetary reform to recognise banks as credit creators and ensure the tool of credit guidance is not abused. Re-establishment of a sovereign for the people by the people government that broadcasts truth, controls the money supply, issues it interest-free for productive purposes and has the best interest of the planet, humanity and all life forms at heart to assist in the natural evolutionary path of ascension for all. The release and disclosure of the true history surrounding the human angelic race, our holographic time matrix, races, technologies, agendas, ascension, creation mechanics, free energy and healing technologies. It's pretty much what I reveal a lot of in here. Is that too much to ask? Is that really too much to ask? Okay, so that's what I was, basically coming in at, what I wanted from this case that I put together, right? So here's the affidavit linked to that. So it's basically just, reiterating these claims, but adding a little bit more substance to it, referencing exhibits that you can see. And so, I start off with, I'm not a legal, tax, accounting, trust, banking, securities, or law expert, which I think is very important to say, so then the court can come to your aid. I'm not a minor, an infant, a tight, incapacitated, insane, a criminal, and any other similar word describing the same. I'm numerate, literate, and competent, have attained full age, full capacity, age of majority as an adult sui juris, and any other similar word describing the same. I'm alive and living. I'm not a corporation, I'm not surety, security, guarantor, indemnifier, trustee, untaught, trustee or accommodation party for any corporate entity and or juristic person that I have not entered into knowingly, voluntarily, and intentionally. I come in peace, and I'm non-belligerent, non-combatant, and always fair dealing, acting in good faith, and friends to all member states, seeking truth, and helping to assist in the advancement and enlightenment of the human race. And just to remind you folks, I affirmed, I didn't swear an oath. So remember, in their good book, under Matthew, it says to swear no oath. And that's how they can get you into contempt of court. So it's a solemn declaration. Sincerely affirms solemnly, and sincerely affirms and declares. All right, and I've got away with also coming in with my proper given name, identifying my born identity, and even signed like that. And if the justice of the peace or solicitor or whoever is witnessing your affidavit kicks up a fuss about it, then you can just say, look, that's what was given to me. That's what's on the certificate of birth, source document, and that's who I am. And I said that to one individual after I got my second affidavit signed to back my originating application to seek leave for the court. He was the only one that kind of picked up on it. That, hang on a minute, you've got just your first name here. And I said, yes, because that is what was given to me. And he just kind of looked at me, and then made a note in his book and just continued. Okay, so you can get away with doing that for sure, because that is technically your name. That was what's given to you. And you can prove that by providing the source document, which I didn't need to prove, but that's otherwise what I said, and he just kept on performing, which is great. So again, just re-emphasizing, see the same things that I mentioned in the statement of claim. So I won't repeat that. In other words, just go over other things that I might have added. Okay, so you can see here, everything's included. So this is all an affidavit backing my claims that I made. As you can see, all the definitions too. And where I input the exhibits, you can see I put refer to exhibit AG2, refer to exhibit AG1, which is the source document. I refer to exhibit AG2, okay, which is the birth certificate, etc., etc. So every claim you make in regards to this is what is on that form, you go, I refer to exhibit AG2, that brings it into evidence. You've got the maxims in law as well. Then here I state a belief. So I believe the surname is Crown property, and it identifies the Crown being made joined to the Son in order for the entity on the birth certificate to act as a transmitting utility in commerce. Okay, so that's a new addition. And I believe this birth certificate security is used to negotiate for more loans when securing the bonds government issues to the central bank for funding. So again, this entity allows one to participate in commerce on the public side and is similar to a corporation sole, wherein it is a vacant position, needs an agent step up a surety for it. Okay, there's the Sedicate Trust. And there again, how the public trustee and the Crown claims the estate through letters of administration and some of the remedies. Okay, then obviously, the letters that I had sent to try and get this process appeased privately that were ignored. And again, even submitting them as evidence, as exhibits, as you can see there, AG4. And also the second letter I wrote to the Governor General once I did the will under exhibit AG5. Now here say, I believe the Crown created juristic person Alexander George Milovic is the sovereign Crown entity identified by the birth certificate. The sovereign successor beneficiary is me, Alexander George, as I'm the only being with an indefeasible absolute vested interest in the estate. As successor and beneficiary, as I'm the only being who has given life and any real value to the estate causing its genesis. Okay, the sovereign's representative is the Governor General, as defined in Chapter 1, the Parliament, Part 1, General, Section 2, and Chapter 2, the Executive Government, Section 61 of the Australian Constitution. Okay, I possess a will written by Alexander George that will amend the record and have all property transferred to me the sovereign successor, heir and beneficiary, referred to Exhibit AG6. And I believe the date of registration for this entity is also considered to be the date of death, which was the 4th of April 1989. I believe that given the definitions and forensics done on the forms surrounding the birth of Alexander George Milovic, that the birth certificate is actually the death certificate, so it identifies a dead fiction entity and or the dead placenta in which I have mistakenly been made an acting as surety for. I believe the place of death for this entity to be either the hospital and or place of registration where the certificate of birth form was lodged by my father or where the birth certificate was created. I believe there may also be a private procedure involved in this process of claiming and creating the estate that may not appease a typical probate under the Uniform Civil Procedure Rules and could fall under general rules as outlined in Part 6 of the High Court Rules 2004. I've been incorrectly acting as trustee de son tort, surety for the straw man. And then, when I was 9, moved to England, acquired national insurance, and then again highlighting the powers of Queensland and the Crown here acting in right of to work with ancillary administrators, and the reciprocating state principle. Okay, so it's just adding a little bit more substance and clout to the statement of claim document that I put together, and referencing the exhibits especially, okay, given also referencing Werner's work, okay, with his published empirical papers too, with Exhibit AG9, and just talking a little bit more in depth about all this, also referencing the case law, okay, how banks are seen in the special debtor or creditor relationship. So you can see I've got more points compared to my statement of claim. Statement of claim I think was like 45 points, right? So have a look, 49. So the affidavit 67. I just basically again put another claim. I'm foreign to the bankrupt public corporate jurisdiction of Australia and all other bankrupt member states imbued with life, freedom, sovereignty, and foreign non-resident tax exempt status. I reserve my right not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally. Furthermore, I do not accept the liability of any compelled benefit or any unrevealed contract or commercial agreement. Okay, so you can see that was all signed off with a certificate of exhibit with the index of exhibits. Okay, so you can see here all the exhibits that I listed. So certificate of birth form, birth certificate, extract from birth entry, public trustee letter, governor general letter, the will of the straw man, national insurance number, government ID showing the bifurcated title set up in the name of the father, as we went through in the presentation, Richard Werner's empirical paper, proven banks as credit creators, and then the other papers showing the accounting, and the other paper, research and proven interest rates follow and don't need economic growth. Otherwise, exposing the whole fraud in academia and regulation and with the media. Okay, and so the will, as you can see here, as we shared on this slide, okay, will upon the demise of the Crown, the sovereign Milovic, Alexander George, juristic person, Crown entity, created under statute after registration with births, deaths, and marriages, declared by this testamentary disposition of this our will and deed. 1. I hereby revoke all formal wills and testamentary dispositions heretofore made by me and declared this to be my last will and testament. I basically modelled this off of what Bill Turner presented with that first paragraph, okay, to come in, the will upon the demise of the Crown, and just looked up simply online templates for wills, okay, and just put in what is required to make a valid will, and then sign it off. Obviously under UCC 120737 3401B, we can sign on behalf of the straw man, okay, under that capacity, and get 2 witnesses, again, appease all the processes of what makes a valid will, and there you go. You put in what it is you would like done. Okay, so number 2, I appoint the Governor General, hereinafter called my representative, as representative, executor and trustee of this my will. So we are letting the straw man speak now in order to instruct these Crown agents and the Governor General, who's personal representative, executor, to have this will appeased, because this entity is dead. It was born dead. It's created as a dead entity, right? So it's through this instrument that we can then have all property disposed of. Okay, so the death of the sovereign shall have the effect of transferring all the functions, duties, powers, authorities, rights, privileges, and dignities belonging to the Crown to the sovereign successor. I give, devise, and bequeath the whole of my estate of whatsoever nature, and wheresoever situate, unto and to the use of my representative for my heir, sovereign successor, beneficiary, Alexander George. I'll just put that in there to make sure it's linked to the right individual myself. born in Brisbane on the 26th of February 1989, okay, to my father and mother, hereinafter referred to in this will as Alexander George, notwithstanding anything hereinafter contained and for the purpose of fully and effectually administering my estate for the benefit of the persons interested therein, or authorise and command my representative to exercise all or any of the following powers, okay, to open a private bank account in the name of Alexander George and do everything necessary to establish a private commercial identity, along with provided knowledge of the procedures and customs involved in such a practice, along with full disclosure of the inventory of the estate being administered and distributed to Alexander George, okay, as well as a few other points that I list that I'm not going to reveal publicly, okay. So if you want to see more details of all this, okay, you must come into the private under a private and confidential agreement. That's otherwise over at my website under sovereignty and law, which will then entitle you to full access to all of my private documents and everything that I've been getting up to, as well as joining and becoming a member, so you can access again all the documents that I share here in this format, which is again keeping everything nice and organized. In other words, going through my course, I'm just going to walk you through A to Z everything I've done and all the things that I found out and refined with the technologies, okay, starting off from the bare basics and then building all the way through module 1, introduction, okay, going through the forensics, what to consider going forward, getting the basic knowledge, quantum grammar and language fraud, okay, shields, seals, emblems and crests, bills of exchange, how to write your letters, status correction, how to discharge debts, fines and taxes, insurance, e-pass bonds, passports and strawman account, certificate of their identity, which you can see there on the right hand side, SEDA KV trust, uniform commercial codes, big one, must learn all this, okay, going through UCC articles 1 to 9, business registration, banking, money, investments, okay, another interesting case I had there of having my PayPal business account reopened by simply sending in my sovereign declaration after they were requiring tax identification numbers and registration of my business. That obviously I was operating unregistered, and they reopened it just simply from my declaration, which is quite interesting that I sent to the Vatican and the UN. Asset protection and estate planning, again, how these guys utilize trusts, faith-based organizations, and linking it to LLCs, private trusts, and 508c1a ministries, okay, which is tax exempt, that you might want to consider. Also go through the 1099 process, okay, which didn't work. I didn't have any success with, but otherwise share, and obviously disclaim at the beginning of every module what to consider going forward, so you can do it right the first time, so you won't be busy tidying everything up. That took me 5 years to perfect, tying off all loose ends and refining the whole thing to where I am today, which is basically refined right here with the latest technologies of all the documents that I've got up and ready that I share with everyone, okay, that you can gain access to. Advanced Treasury Pack Redemption Process, again, this was from PJP, Peter Joseph Polinsky, Gene Keating, and Patrick Devine, which again fell short. There was a few things that I later realized that needed to be implemented, again coming in with the correct name first and foremost, that these guys didn't pick up on, but otherwise, you know, went on and did better things and, you know, improved that pack in order to then now be where I'm at with regards to the bonds at the Treasury, using the correct language and the correct procedures with the correct names, okay, when it comes to using the bonds now for set off, okay, with the cover letters and how to administer that on the PPSR and assign that even with the UCC as well. Okay, so you guys get access to all of this, the indemnity bond, the set off bond, and with that you get lifetime access to the Telegram group as well, where I'm constantly updating people and individuals who are members as to what I'm working with, what I'm, you know, got going on with cracking the codes even more, especially no more so than this current court case, okay, that you folks at a huge discount can, you know, get your hands on and come on board and jump from the public into the private, come join the movement, contribute, get up to speed very quickly, because you need to know all of this. Trust me, there's no shortcut to becoming a sovereign, and it's taken me 5 years to get to the point where I'm at, where again I can put together a claim, statement of claim, go through the court, stand on my own 2 feet to, you know, work out how to liquidate this estate, but in the meantime have set up everything I need in order to operate this theatre of commerce, this monopoly board game, with safety and power and sovereignty. Okay, and otherwise, this is the originating application. So I filed the initial claim statement of claim. The registrar refused without leave of the court because he deemed it as being vexatious or frivolous. And so then I filed or went to file originating application seeking leave of the court to commence proceedings. Again, this is otherwise what I've submitted, and they're just hashing out now, determining a date and a time for me to rock up in court and, you know, present and talk through all of these papers and procedures in order to, you know, open up the case so I could go against the Crown, that the Crown has to otherwise prove and strike off with my affidavit and disprove all of what I've written down here. That obviously, otherwise I've proven with the exhibits that it's going to be very difficult for them to do, near impossible. So we'll see what they do. Be quite interesting. They can play silly buggers and deny, you know, wanting to go ahead with it, and I could just appeal to the High Court, and that'll get things done. And or I can kind of just readjust, and that's what I can discuss with the judge and court. Some of the claims that I want to make in regards to, you know, I'm going after damages to the value of 1 billion, which is quite a lot. And the judge even came back to me and said that this is quite a complex case. Okay, I'll just show you guys. So I've got to prove what I'm saying here. Supreme Court. So you can see here, you can read through, this is all public knowledge anyway. It's okay, I don't mind sharing this, so I think it's going to help everyone anyway. So under this regulation, 15, register may refuse of issue originating process to court due to, you know, frivolous or vexatious, which certainly it wasn't. And there's a letter proving that. And otherwise, this is what they offered for me to file for leave of the court, which I did. Okay, and there's the originating application seeking leave to commence proceedings. Okay, which we'll go through in a second. And then he actually got back in touch. As the time estimate for hearing of the application has been revised. All right, okay, so he basically got in touch to say that this is a very complex case. Okay, so we believe it's going to take more than 1 hour, which is what I estimated. Okay, so I estimated instead 3 to 4 hours. And so they're now just, you know, reassigning a time and date where that can be heard. But I think based on my correspondence with the emails, because the Crown prosecutor chipped in, and I kind of countered, because she chipped in saying that we can't see any Crown law being utilised here. Okay, so I came back with this. Let's have a look. Thank you for the update. The matter at hand involves Crown property and all agencies involved with the executive, legislative and judiciary, in which the Crown acts in right of. As agents of the Crown who have sworn an oath to uphold statute, the Crown, in its representative capacity, is liable for harm and wrong, as well as being the engineers and administrators of this system, which my case reveals and questions the morality and equity of. And then here's a few of the legal maxims. Give me the facts, I will give you the law. From fact springs law. Law arises from fact. And deceit and fraud should always be remedied. Okay, so that's kind of, I've not heard from them since, but they should be in the process of giving me a date, right, to go ahead with proceedings. And otherwise, just to reiterate, I think under the claim and statement of claim, if you guys want to sue the Crown, you should be able to find in legislation the representative for the Crown, okay, and who you can sue based on that, okay, which would be the Crown Solicitor, and this is normally done under the assertion of, I think I put it under the statement of claim. Let's have a look. It's codified in legislation, okay, which I think is under this one. So the respondent is sued in a representative capacity as per the Crown Proceedings Act 1980, Part 4, Section 19(1). Okay, so if you look that up, wherever you are, there'll be an equivalent act that shows you who you can sue when you wanted to sue the Crown, that there's going to be a representative, okay, Crown Solicitor. In this case, it is this individual. Crown Solicitor Cecilia Christensen, Crown Law Office. Okay, so that's who you'd want to be addressing it to. So this is otherwise what I filed in response to me combating and saying that this is not vexatious or frivolous, guys. You know, yes, it's a special case, it's complex, but it's certainly not frivolous. So I've done my homework and I've got the evidence and I can prove it, and that's the right that I've paid to appear in front of a judge in the court to present my case, to say that, you know, this is not, you know, frivolous or vexatious at all. And, you know, I'm in possession of the will and this is all the evidence. You try and rebut it, they wouldn't be able to. So again, just highlighting here, you know, to the respondent, the Crown State of Queensland take notice that the applicant is applying to the court for the following orders. And again, re-emphasising it, you know, power to revoke a grant of letters of administration, just pretty much listing all the acts that I'm relying on in order to have this process appeased. Okay, ZKV Act, Public Trustee Act that we've already gone through before. And you can see there how I've kind of explained why I'm relying on this act given my situation, which again gives it more credence. Okay, and then obviously, the private bank account set up in the name of myself according to the will, amendment the record, and again everything that I kind of just reiterated in the statement of claim. And again, set up. So for the damages, I can claim this pursuant to Crown Proceedings Act 1980 Part 2 Section 11. Okay, and then the respondent paid the applicant's costs of application or other court fees, and then such further or other orders as this honourable court deems fit. All right, so if you guys want to keep updated with this case, okay, and project that I've got going on at the moment, then sign up, become a private member, invest in yourself, pay it forwards, and gain access under a private confidential agreement with obviously everything I've got going on, and to all the future updates. It's got a lot of other things I want to work on as well. Okay, and you'll be able to gain access to all of these documents, okay, that I've otherwise already proven that with the bonds, this is what I issued. Okay, this notice being sent to your attention by written communications for the following reasons and information. As secured party creditor and sovereign, I hereby issue a surety bond to the value of £1 million as security to settle any claim of liability in the event of an incident requiring compensation from another living soul. Please find the surety bond and terms and conditions attached for your record and safekeeping. Due to the very fact that securities have now replaced substance as collateral for debt due to the bankruptcy of the United Kingdom Corporation, to the IMF, including all subsidiaries in government in their private capacity, corporate capacity, and that there is no money in circulation of any value in which to pay only debt, and all debt is created on paper, therefore all debt can be discharged and issued on paper. I exercise my right and unlimited exemption to use this negotiable instrument to ensure that Alex Middleditch, secured party to Capital Alex Middleditch, and any and all personal vehicles owned by Alex Middleditch involved in any incident is hereby covered by this bond to the value of £1 million. Okay, you agree that a copy of the bond is proof of insurance unless explicitly stated otherwise. Sign this as acquiescence. Yours sincerely, without ill will, vexation or frivolity. And you can see here, even at this stage, for this very early stage, I didn't know the separation of the names. You know, still came in thinking that my lower case name with the given name and the surname was representing my true self. Then the all capitalized was representing the strawman fiction. But they knew what I was trying to do. So it just goes to prove that even when you do kind of make these errors, it doesn't have to be completely perfect. It's the substance of what you're trying to get to lock in agreement under silent acquiescence when sending in these bonds that they end up performing when litigation ensues, right? And this is the big secret that I revealed that made me realize that it's the bonds that are the secret and the indirect way for us to access our unlimited funds with the ZKV Trust that can protect us when operating in this world of bankruptcy. Because remember, everything in bankruptcy must be licensed, bonded, and insured. Okay, so here's the bond. Again, wasn't perfect. I've otherwise perfected this and show this, you know, with my set-off bond printed on the back of the birth certificate as well, okay, with the correct language. But this is otherwise highlighting what I issued for insuring myself with the car. So I tried all of this out, finished my insurance that I had that I was paying for with the private company at the time. Once this bond was locked in, after I think I gave them 30 days for them to respond, didn't have anything back. I knew this was then locked in law under equity contract law through silent acquiescence, because they did not send anything back and can prove they sent anything back via registered post, right? To prove to the contrary that they want to obviously refuse acceptance of this bond's performance, that when I inevitably got pulled over, okay, by a copper for not having insurance on their system, That otherwise, again, I should have notified. This was all me trying these things out. That otherwise I go through at the moment, okay, as you can see with this, that otherwise I show, with the exhibits, document of allodial title, private indemnity bond, okay, worth 100 million, schedule fee, etc. So when you're claiming a allodial title and dealing with these folks and actually notifying all these agencies, you can make sure you do everything right the first time. But this otherwise revealed to me the nature of the system, because they issued a fixed penalty, obviously when pulling me over. The copper wanted to issue it to me there and then, but he couldn't because I had this in the glove box, this letter, so this cover letter and bond. So he goes, do you know why I pulled you over? I said, no, not at all. Please inform me, and lie to me. He goes, oh, because you have no insurance. I go, but constable, I do. And I went to you allow me to go to the glove box? Yep, I got some papers. I showed him the papers and he was like, that's interesting. He pulled out his little book. And I remind him of a little, I think, act in one of their police books that says that if there is a bond held with the court up to the value of £500,000, then that can be deemed valid insurance, which I found quite interesting. And he goes, have you got a bond with the court? I said, no, but I have got a bond with the Department of Treasury, as you can see with the document. And that basically stopped him issuing a fine there and then and seizing my car on the spot because I had those documents. Okay, so all he could issue was a hort, which then was for me to go into the police station to kind of resolve this issue and, hash out the papers and try and, sort this problem out within 2 weeks. Okay, so the next day I rocked up to the police station, still was able to drive away, after they stopped me, presented the papers, and they were on the phone trying to find out, what insurance company are you with? I said, no, I'm not with an insurance company. I've got a bond held with the Department of Treasury, as you can see here with the letter. Oh, okay, they were so confused, scratching their heads, right? And they're kind of like looking at the papers and thinking, what is going on? I had no idea. So they were like, okay, well, leave the papers with us and we'll get back in touch. So again, walked out of there scot-free, couldn't touch me because what? I had the papers. I had proof that I sent this, registered post, etc. Okay. And it was signed for, so I had all that proof with there as well. Anyway, 2 weeks later, I get this letter through the post, this presentment. Okay, so they obviously decided, we don't know what's going on. I don't think he's got insurance, so we're just going to issue the fine and penalty anyway. So fixed penalty, as you can see here, right, for the details, I think it was £300 or £600 and 6 points on my license. And yeah, there were £300 and 6 penalty points on the license. So obviously I wrote back rebutting their assumptions, presumptions, put the record straight as to what I had in effect, and otherwise also asking questions on the conditional acceptance. Sent in a copy of my bond as well. Okay, and then otherwise, after all that was said and done, got a letter back, which is referencing the fixed penalty number with reference to your previous communication regarding the above offence. The offence has been reviewed, and I write to confirm that the fixed penalty noted above has been cancelled. So that I had my first proof in success in successfully discharging a fine and a presentment and points on my license by having this bond agreement and this silent agreement in place. Okay, that soon as litigation, the solicitors came into the forefront, obviously after me responding to the initial fixed penalty and conditional offer. Okay, what's a conditional offer? You can refuse, it's an offer to contract. So I refused it under conditional acceptance, and although I set the record straight that I did have a bond, see, in which I attached to the letter with the actual, registered bond receipt or the bond number, okay, proof of postage, they could not touch me. Okay, so the solicitors obviously got involved and they knew exactly what was going on under equity with contract law. Everything is contract law, that it brought the bond's performance into the forefront, and so they knew I had valid insurance. Okay, now if I was in an accident, then the Department of Treasury, the holder of this bond, would have to perform. Okay, but this is where, ever since, perfecting this technology, where I've obviously got this with the cover letter and everything else with the PPSR filings, I have tried to do the A4V, okay, as you can see here with the cover letters, referencing the bonds, dealing with any agency that are kind of coming after me for performance of the bill, that I then, CC them in and forward onto the Treasury, giving them a copy of the bond saying, hey, look, they're now my payor and juror in the matter. So any future correspondence, just please send to the Treasury, because that's my bank. I've got a bond there. Here's the proof. So all I can do is just endorse the bill and have it set off and then forward it on to, the Treasury, who is the juror in this matter. And what I found is that they the Treasury is reluctant to honour the endorsement and the set-off of these bills because we're still coming in as a trustee de sumpter capacity, right? Until we learn to liquidate the estate, they are reluctant to want to perform, okay, in discharging this bill. However, they're also reluctant to want to enforce litigation because then that will bring the bonds agreement in place, okay, when we form the silent agreement through silent acquiescence with the Treasury when issuing these bonds that we can rely upon. So it is a checkmate situation. It's the best of the best scenario we can have at this time that I've worked out until such time we learn to liquidate the estate, which is what I'm going through the court case at the moment. Okay, so with this, I've not been paying any bills for over a year now, no hassle. It's just an automated process. Most of this is just computer generated anyway. I still get reminders of having to pay this and they, threats of enforcement, but nothing ever happens. Okay, because I know if they start actually bringing in litigation, then I can respond to that like I did with this case with the insurance bond, which will bring it into question, and they will have to act as fiduciary and perform, given the bonds agreement, okay, the terms and conditions there, and they're going to have to discharge the debt. So it's just one of those that they're in stasis. They're not willing and honourable enough to want to perform because we're still acting as technically a trustee de sumpter, meddling with their estate and trust, okay, until such time we learn to liquidate the estate. That's where I'm going to have a true remedy, and that can only be done through a will, because all property may be disposed of by will. Okay, so all of this, including the tax exempt status, foreign status that I have issued here in Australia and the world over, okay, with my set-off bond, indemnity bond, PPSR, UCC1, okay, etc. You guys can get access to. It's a 52-page document. The A4V as well is a 5-page document, obviously revealing the process of doing this once you get all your bonds set up and all the proper filings. 17-page document this is, with the cover letters, PPSR filings, UCC filings, being able to perfect, control and assign these securities. And also, when it comes to issuing a allodial title to private conveyance, you can also do that as well. 30-page document. Been doing this in my car, where I have issued private plates and have been driving around no hassle for over a year now here in Queensland, Australia. No problems, because I know if I'm in an accident, the bonds have been accepted, and whoever the holder of that bond is going to have to perform in order to compensate individuals involved. Again, it's just a matter of when you have the knowledge of what these instruments are saying, you know exactly what to do if and when events arise. Okay, and I know this is all true and can be proven because I've got the proof here with this bond, which was very rudimentary. Okay, didn't even kind of sign it properly. I just kind of used 3 different variations of my name. It just goes to show it doesn't really matter. This is all intricacies. What matters is the substance, okay? The indenture, what is being said, what's the bond order, what's the terms and conditions. And then once you clearly identify that this is going to be locked in after 30 days, it's contract law. It is law, okay? There's nowhere they can get out of it, okay, when it comes to them performing, all right? So that's how I found at the moment, given 5 years to reach this point, the pinnacle, that I'm in a very solid, watertight situation of a checkmate with them. There's definitely more I can do with the bonds in regards to trying to get them to perform when maybe issuing promissory notes backed by that bond, and also grabbing hold of purchase agreements to make secured transactions, which I have tried, but it's just that trustee de sumpter capacity that I believe needs to be collapsed in order for us to really find that remedy to ultimately, gain access to what has been traded in that name backed off of our life force essence here, when liquidating the estate, which seems to be the remedy going forward. So we're not in that trustee de sumpter capacity, we're not meddling with the estate, okay, we're then identified correctly within the system, we have ID and everything involved with them on the private side of the ledger within the commercial theatre, in order for us to be free and come out from amongst them, my people, as it says in the Bible. Okay, so let's just see what else I put down here. So in the meantime, just to reiterate what basically already said, I've worked out how to operate in the theatre of commerce whilst not being bound to perform as surety and agent for the strawman, but as principal and secured party creditor to the entity through the technologies I've learned and perfected over 5 years of study and application that I teach others to do inside my course. This means I'm able to stay protected, claim tax exempt status, have indemnity and set off bonds in place, register my own allodial title to private conveyances under my own hand and seal with my own court using the postal road mechanics. I'll show you how you can issue, control and perfect your own securities utilising the security agreement, indemnity bond and set off bond, which is essential to have and is a necessity in bankruptcy. It's evident in bankruptcy. It's bonded, licensed, and insured. I'll show you how you can negotiate your terms and conditions when setting up your sovereign status and protection, and get their consent through silent acquiescence, which is honoured, as I've discovered. Having the set off an indemnity bond in place gives you the freedom and backing to start issuing your own legal title and registering private conveyances under your own hand and seal, removing it from their bankrupt pledged collateral jurisdiction, and also allow you to start accepting full value bills issued in the name of the strawman. I've had written proof that bonds are the only way to indirectly access our funds, that these guys honour with my car insurance case when litigation is involved, and those who know what I am doing come to deal with the matter, aka solicitors. Okay, there is a silent agreement I found with accepting for value bills when establishing your set-off bond at the Treasury and using the Treasury as your drawee payor whenever dealing with bills sent your way, where there is still this reluctance for the Treasury to want to perform, as we are technically still acting as trusted decentor. However, the drawer of these bills knows that they can't enforce payment through litigation, as that will bring the bonds into question and show the agreement held with the Treasury where they will be under fiduciary to perform and settle the bill, as I found out with my car insurance case. And also what I've just A4V with a few bills here off the back of my latest set of bonds held at the Treasury here in Australia. So they just ignore and keep sending automated updates of overdue bills threatening enforcement, but never do. In this situation, as proven with my car insurance case, we almost want litigation, as that will bring the bond and performance into action that the Treasury will have to accept and perform to set off the bill. So it is a checkmate situation, and the best scenario I've found to benefit from this technology until such time we learn to liquidate the estate. So the bonds are printed on the back of our birth certificates using the correct layout, names and wordings, and secured, controlled and perfected on the PPSR UCC public notice board for security interests. With the security agreement, guys, you have the security agreement. It's one of the most powerful documents in the meantime for you to stay protected until you learn how to liquidate the estate. So if you want to get up to speed, come join my course and get access to all the materials and other members via the Telegram group. I charge because I invested around 10,000 Great British pounds myself to attain all this information, as well as 5 years of my life trying it all out and sharing firsthand my results with paper trail back and forth. And I know the importance of paying it forward and supporting others within this movement, as what you put out, you get back. It's universal law. And I know the psychology of investing in oneself, that if you give someone something for free, they seldom assign any value to it and do not invest the time and energy of what it takes to be sovereign, as being sovereign can't be spoon-fed, it must be earned. So the price is a good marker that is at a huge discount for what is shared, but also separates the wheat from the chaff when it comes to psychology and those individuals possessing the qualities of mind to be successful in this journey. Okay, self-starters, self-motivated, disciplined, asking how can I afford this, or how can I raise more money to afford this, how can I get this done, etc. It's a positive mindset, right? Rather than, oh, I can't afford this, oh, that's too expensive, oh, life sucks, oh, this system's so evil, I'm never going to get my remedy, just to give you an example. So I know myself, I wouldn't be here if I fell under the latter kind of mindset, always paid my way forwards, and also knew the importance of investing in yourself and investing in others on my journey, which I had done and spent a lot of money in, and thanked them for their time and moved on to the next thing. And that's why I'm always adapting, changing, going back to the drawing board and giving even more value, which I left the price at many, many years ago, and I just kept adding value and not upping the price. So you get an absolute bargain with this. And yeah, trust me, the cosmos is watching. And yeah, it's about time we all start helping each other and invest in one another in order to help provide the remedy. I've provided a lot for free as well, but it's just also getting people into that private confidential agreement that transaction will invite you in order to access and protect myself and my documents under that agreement, so you can gain access privately, securely, so I can be protected, you are protected when getting access to all of my documents and seeing exactly what I'm doing and working on with all my successes, okay, and projects going on. So the people I invested in and studied to get me here are the following: Bibi Bacchus from New Earth University, used to see Strawman Redemption. Bless her heart, she recently passed away, I think in early part of 2025, I think last month, so I think in May or April. Okay, so rest in power. Wish her safe passage onto her next mission. And she was certainly the stepping stone for me, that opened the doors to the Strawman deception after reading Mary Elizabeth Croft's PDF, How I Clobbered Every Cash Confiscatory Agency Known to Man. Okay, then obviously stumbled across Bibi Bacchus. Great introduction, but then, had a lot more questions new. There was a lot more to find out. So yeah, just went on to the next one, the next one, the next one. And yeah, stepping stones, gleaned a lot of wisdom from all these individuals and, paid my way. So the next, Mark Christian Christopher was the next guy that I came across through the Legal Tricks and Traps Soul University. We achieved values in sales for £7,500. Okay, that I did. So Don Calam's University as well in the United States. I came across Bill Turner's material, so I invested a lot with him. Bill Turner's material online, went through all of that, spent a lot of time making notes and decoding all that and applying it to our situation. Dave and Wynne Miller's material as well, that kind of Mark Kishon Christopher reduced into more bite-sized pieces as to how you can put that practically into use with the quantum grammar language fraud, which is very fruitful as well. Peter Joseph Polinsky's materials with the Treasury Pack, Gene Keating, Winston Trout, the Redemption Manual series, ABCs of the UCC, banking law and other published books relating to money, banking and law. Okay, so it's a very comprehensive course that I've kind of weaned the best of the best bits from all these individuals, saw what worked, what didn't, blended it, refined it, and still, applying these technologies and kind of got to the pinnacle now, as I said before, the peak of this journey where I'm pretty, happy, 100% certain of exactly what's going on to the point that I'm confident enough to go to court to sue the crown, as you've seen. All right, proof is in the pudding. I can walk the walk and talk the talk. Substance over form in my behavior certainly matches my assertions. And yeah, just read the testimonials on my website and all the people, what they have to say. Okay, it's full of value, very empowering, and yeah, definitely invite you guys to jump on board. So again, just to wrap up, 10 maxims of law, pretty easy. Got this on my resources, won't have to go over this, but it's very important. Just a good little snapshot taken from Bill Turner's website as well as to what's happened and where our remedy lies. Okay, everything is contract. That's where our remedy lies, especially with these agreements under silent acquiescence that we can bind them under, okay, with these bonds and terms and conditions, as I've proven. And at the end of the day, these are only pieces of paper. Paper is a written or printed document or instrument. It's a negotiable document or instrument evidencing a debt. Okay, it's all debt, unfortunately, all negotiable instruments. And once you become empowered and knowledgeable, you know how to use these negotiable instruments to negotiate your freedom. Drop the fear. Fear is just false evidence appearing real, and that can only be done through education, okay, because they only rely on ignorance of the law, ignorance of what's going on, in order to fuel fear. Fear only comes from ignorance, and what dispels fear and ignorance? Knowledge, true understanding. So the pen is mightier than the sword. That's where we find our remedy. Never argue, never agree without condition, never fall silent. That's the conditional acceptance. Okay, ask questions, act as king. The King's and Queen's Court is your documents bearing your seal, the four corners where we reserve all our rights, the right angles, okay, and all property may be disposed of by will. And, this stage, you've got to take responsibility, be accountable and level up. It's all down to you. At the end of the day, you're the one that you've been waiting for. Study hard. Remember, you only get out what you put in. Draw inspiration from my journey, okay? So I've definitely had a lot of success in this, and through me, you can get up to speed very quickly with the perfected technologies. Be patient, let your spirit grow into this, and best of luck on your journey. And I hope this presentation has helped you folks out there in the public realm. And to finish it all off, beautiful song that I got kind of sent from my higher self to listen to the lyrics of, which was quite fitting in regards to where we find ourselves, going back to the beginning of being the Word. Okay, the Word was with God, the Word was God. So what is God? The Word. All right, and how important it is to define our existence, and especially what they define in regards to the tricks and traps that we decoded with the forensics and the forms that Natasha Bedingfield and Unwritten in her lyrics, just going to read it out. Okay, one verse is, I am unwritten, can't read my mind, I'm undefined, I'm just beginning, the pen's in my hand, ending unplanned, staring at the blank page before you, open up the dirty window, let the sun illuminate the words that you could not find, reaching for something in the distance, so close you can almost taste it. Release your inhibitions, okay? Feel the rain on your skin. No one else can feel it for you. Only you can let it in. No one else can speak the words on your lips. Drench yourself in words unspoken. Live your life with arms wide open. Today is where your book begins. The rest is still unwritten. Okay, if you do not know your rights, you effectively have none. And if you do not put pen to paper and express your terms and conditions, contracts and definitions, then you will fall subject to the will, terms, conditions, and definitions of others. Okay, and if you can define it, you've defiled it. Okay, so it goes back to the most important thing and how they've managed to renegotiate our standing and dragged us into the world of fiction is through the word and definitions. Okay, and that's the most powerful thing we can rely on, that we need the knowledge of in order to stand in front of a blank paper with a pen in your hand. What can you put forward on that piece of paper based on your knowledge? Okay, so this whole course is designed to get you up to the level of knowledge where you can have a blank piece of paper put in front of you and negotiate with these folks off the top of your head, knowing full well what is going on, what is happening, so you can seek your remedy. All right, guys, so hope that's been educational for you folks. Just double check I've gone through everything I want to go through. So we've got the will, went through that, went through my originating application, okay, as you can see here, which had with it an affidavit too. And the insurance, we went through, foreign tax exempt status that I share inside the course, the A4V using the latest bond technologies, and claiming a allodial title to private conveyances and notifying all the correct agencies once having your indemnity bond and set-off bond in place, and my Supreme Court case. All right, folks, like I said, if you do join, you get access to the Telegram group, which has all the updates, all the discussions, member wins. It's over 152 members at the moment. Okay, you're also entitled to the email updates. You're entitled to a free consultation with me once you've gone through the whole course. Okay, so we can just have a chat and I can answer any questions that you still have. You still got access also to the website, and when you go into, for instance, watching the video lecture relating to that module and topic, you can scroll down and see relevant questions and answers for each subject below the video and ask questions there for other people to benefit from. And as I said, there's over 17 modules, okay, and the way I kind of geared it at the moment, I've left everything there so you guys can see my evolution in this journey, but guide you from the very beginning to consider the most advanced aspects of the technologies, but work your way through it so you can accrete the knowledge base. And then once you get ready to put your papers together and get your bond set up and your security agreement, your filings done, and you have the base level knowledge of knowing how to manage your estate and play this game, then you can go ahead, do it right the first time, so you won't be busy like me. It's taken me 5 years to kind of get to the point where right now, if I was to tell myself 5 years ago this is how you do it, I would have saved a lot more time, which is where the value is in this course. And then once you have all that established and you have a good understanding as to how to deal with these folks, and you go through your kind of rites and rituals and passages of initiation within this sovereignty movement, then you can certainly start collating and doing the forensics and the forms in order to go after liquidating the estate. All right, and that's the ultimate solution. And if I have success, of course, I'm going to notify everyone within the private Telegram group, okay, of the outcome of this, so people can follow in my footsteps, so to speak. All right, folks, I hope that helps everyone out there. As always, stay safe, stay sovereign, and I'll see you on the inside. Okay, ciao for now. Stay blessed. All the best.